Good afternoon, everyone. Welcome to the Appellate Division First Department. This afternoon, we have about 7 hours of argument time requested, so please keep that in mind. When I call the calendar, please ask only for the time that you need to make your most important arguments. Understand that we have the record, we have your briefs, and we're fully familiar with the facts of this case. Before I go further, I want to welcome and introduce some students from the Bronxwood Preparatory Academy in Bronx, New York. They are here as part of the court's Justice Forward Initiative class visits program that we have monthly. And we are very pleased that their teachers, Keon Forbes Brown and good afternoon, and Danielle Taylor have escorted these very eager students here this afternoon. Hopefully they will learn something this afternoon as opposed to being dissuaded from the legal system. Let's make sure they are even more excited about becoming lawyers in the future. So hope you enjoy and find this interesting. Okay. Okay. People versus Marlon Cruz. Five, 2, and 3. Thank you. Qui versus the City of New York. Five, 2, and 5. Naomi N. is submitted. Mosley versus RCPI Landmark Properties. So appellant, how much time? And, okay. 4, 1, and 4. Lava Media versus Hart. 5, 2, and 5. Thank you. People versus Lonzell Green. 6, 2, and 6. Ellen Stardust versus Sturm, submitted. Thor 138 North versus Goldberg, Weprin, and Finkel.
Good morning, Your Honor. Joseph Lee Madelon, the plaintiff appellant, and would very much appreciate 7 and 4.
Yes, and good afternoon. 4, 1, and 4. McFadden, W. McFadden, submitted. Butler versus Marco Realty. If you could just keep your voice up, please. Six and 2, 3, 2, and 4 minutes. Thank you. Rubin versus Kalon. Thank you. 5, 2, and 5. Fernandez versus Sub 412. Somebody want to tell me who the appellant is? Next. Five and two, 4 and 2, 5 and 2, and 5. Thank you. People versus Gregory Darby. Five, 2, and 5. Thank you. People versus William Bunce. Bunch. 4, 1, and 4. Day versus Plummer Shop and Associates.
Attorney Ron Frank, occupant for plaintiff, respondent, request 3 minutes.
5, 1, and 3. People versus Renee Rodriguez.
Good afternoon, Your Honor. The people request 4.
4, 1, and 4. NYCTL 2019 Trust versus 196 East 7th Street. Okay, you didn't request any time on your appeal. I'll give you 2, 2, and 2, and I'll give you 4 minutes. Thank you. People versus Clinton Benjamin. Submitted. People versus Samuel Watts. Five, 2, and 5. SM Infant versus the City of New York is submitted. First case for argument is People versus Marlon Cruz. You
Good
may
afternoon, Your Honors, and may it please the Court. Marcia Kubishko, appearing pursuant to the Student Practice Order under the supervision of Jesse Hussey of the Legal Aid Society, for Marlon Cruz. Your Honors, Mr. Cruz's criminal conduct cannot be understood without considering the extraordinary mitigation present in this record. His particular history reflects lifelong struggles with trauma.
Hasn't he had several opportunities to deal with that history? And quite frankly, he's failed at it.
Your Honor, it is true that Mr. Cruz absconded from treatment programs twice. However, treatment is typically not a linear process for many individuals, and they fail before they're able to succeed. And what really sets Mr. Cruz apart is that he is a unique example of someone that has showed honest and genuine remorse to the sentencing court. And not only did he accept responsibility and plead guilty, but he also apologized for not only the crimes that he committed, but also failing to succeed in treatment. And during sentence...
Counsel, at this point, you're arguing as to the sentence. Do you have another issue that might precede that needs to be determined?
Waiver.
In regard to the waiver of appeal here, under the totality of the circumstances, the waiver was deficient. In regards to the two oral colloquies that were given in this case, they had similar deficiencies. First, they did not explain what an appeal was before going into the list of surviving claims. Second, they did not explain that counsel would be provided during the appellate process. Third, and more critically, the waiver did not accurately state the difference between arguing that a sentence is illegal and that a sentence is excessive.
Do you have to explain what an appeal is?
Your Honor, there is no requirement for any oral colloquy to make it extremely the same. However, when compared to the model oral colloquy in paragraph 2, there the court does begin the paragraph with what is an appeal and explaining the rights of appeal.
What about the written waiver? How does that affect your position?
The written waiver in this case does not cure the deficiencies that are present in the oral colloquies, as it can supplement, but it cannot substitute for an adequate oral colloquy. And I also want to point to the totality of the circumstances here. The confusion was really compounded by many factors. There were multiple plea proceedings in front of different judges regarding different charges, different waivers, and promises of diversion with different stipulation given months apart. And given Mr. Cruz's documented history of mental illness combined with the procedural complexity in the case, the waiver fails. In moving back to the mitigating circumstances here, Mr. Cruz has a more than 30-year history of addiction that began in his adolescence after childhood sexual trauma. And Mr. Cruz's crimes were largely theft-related offenses that were tied directly to his addiction and his
Were
attempts.
these issues known by the trial court at the time of sentencing? And if so, how does that affect our decision at this point?
Your Honor, these facts are in the record from what the sentencing court considered. However, this court does have jurisdiction to review all of the mitigation altogether one more time to determine the appropriate sentence. And as I was saying, Mr. Cruz's crimes were largely theft-related offenses tied directly to the addiction, his mental health struggles, and his attempts to survive on the streets of New York. And Your Honors, the question here today is whether Mr. Cruz's continued incarceration is necessary. And at this point, Mr. Cruz has successfully completed treatment program, and what remains would be better suited to be addressed in the community through supervision.
Just a question for you. Now, the court was aware of the mitigating factors, because isn't that one reason why the court imposed a concurrent rather than consecutive sentences? You know, this happened on several dates.
Yes, Your Honor. And, you know, 2 chances at diversion were all the court was willing to give here, and perhaps that was appropriate, but the focus again is on Mr. Cruz's continued incarceration and whether it is still necessary. And at this point, connecting him with supports in the community and reconnecting him with his family support system would be more than the minimum sentence would provide the accountability that is necessary and provide him for ongoing supports in the community in a way that's a lot more effective.
And here, the court declined to impose the sentence that the people requested, imposed a lesser sentence.
Yes, Your Honor. And for the reasons that I discussed above, we respectfully ask this court to reduce Mr. Cruz's sentence to the minimum on all counts to be served concurrently, and this modest sentence reduction really reflects the mitigation present in this record while also addressing the accountability necessary. Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, Andrew Kim for the people.
Counsel, I'd like you to focus on the waiver, which seems to conflate what the trial rights would be, and doesn't seem to discuss what happens at a plea at all.
Yes, Your Honor. The appellate waivers, the oral colloquies of the appellate waivers handled by both of the courts below were rather thorough and quite detailed. They both, excuse me, they both make clear that the rights tied to the right to appeal was separate and distinct from the trial rights that the defendant would automatically forfeit.
Well, was
on a
that
plea
based on the
appeal to.
oral waiver or the written waiver?
It was based on both, Your Honor.
Well,
It
let's
was,
take one at a time. What
Yes.
about the oral waiver? If there was no written waiver, I know there was, if there was no written waiver.
yes, Your Honor. The oral colloquies, I think themselves would be sufficient here. The court almost mimicked the exact language in the written waiver, and both courts, I would note, almost mirrored each other, right? Both of the judges below pretty much had the
That makes
same
them either
exact
both
oral
good or
colloquy.
both bad, right?
My apologies?
The fact that they mirrored each other, that makes them either both good or both bad.
Yes, Your Honor, and
So specifically, the question I have for you is, so here the transcript shows that after the judge explained the rights that the defendant will be waiving, this is what occurred next. It says, in addition, if you had taken this case to trial and had been convicted, you would have the right to appeal any errors made in this case. That's a misstatement of law, correct?
well, I think I don't think that's a misstatement of
It
law.
is a
Your
misstatement.
Honor.
So in other words, does the defendant have the right to appeal what's happening at this proceeding? Because he's not taking it to trial, is he?
Yes, Your Honor. He would have the right. I'm sorry. Could you repeat the question?
In other words, what the impression that the judge gave with that sentence is that the appeal rights apply only if you had taken the case to trial and been convicted, which is not what happened here.
I don't think that that's what that statement implies, Your Honor.
That's what it
The
says.
words are. And so then you have a written waiver that really doesn't clarify something that someone's already confused about.
Yes, Your Honor. I understand that concern,
That's not just a concern, that's the law. There's supposed to be a clear waiver of rights.
I think the courts below were trying to articulate that had the defendant gone to trial and was convicted, there would be rights that the defendant would have.
That would be sufficient if they also followed it up and explained maybe there are other ways that the appeal waiver survives. But if you just limit it to that one particular part, it's very misleading. Wouldn't you agree?
It could be, Your Honor, and I think what's important here is that the oral colloquies were, in fact, supplemented by the written waivers of appeal, which defendant reviewed and signed. He had the same defense attorney across all of his proceedings, and so there was no real point of confusion here as to the nuances of these waivers that could arise had, for example, the defendant been represented by different attorneys. The defendant made multiple assurances to the court that he understood what these waivers entailed, and based on this record alone, Your Honors, there's no reason to doubt those multiple assurances to the courts below. Thank you, Your Honors.
Brief rebuttal, Your Honors. First, in regard to the waiver of appeal, as Your Honors noted, one of the limitations of the two oral colloquies that were given are that they imply that the right to appeal was conditional upon going to trial. And the written waiver here does not cure that, as it can only supplement but cannot substitute an inadequate oral colloquy. And turning to the mitigation here, the people in their response say that Mr. Cruz had many chances and that he failed them. But what the people call many chances were not Mr. Cruz's refusals of help. They were his attempts to survive untreated addiction, severe mental illness, and homelessness. And the failure of Mr. Cruz to succeed at that time was the combination of those three conditions with years of trauma that were never meaningfully addressed together in the community. And the record shows that Mr. Cruz's conduct was largely addiction-driven. So the minimum term here provides the necessary accountability. A modest reduction in this case does not excuse Mr. Cruz's conduct, but it accounts for the extraordinary mitigation present in this record. And it allows for supervision and treatment to occur where they are most effective, in the community. Thank you, Your Honors.
Thank you. Thank you both. Cui, I apologize if I mispronounced that. Cui versus the City of New York. Sir, you can step up to the podium.
Good afternoon, Your Honor.
Oh, hang on just a minute.
Good afternoon, Your Honor. May it please the court, my name is Hugh Moe. I represent the petitioner in this appeal. And, Your Honor, at
So
the
let me just
outset,
get right to it and ask you, this court's review of administrative agencies and determinations after a hearing is quite limited, as I'm sure you're aware. And it's limited to whether the determination was supported by substantial evidence. And substantial evidence is only that proof that a reasonable person may accept as adequate to support the conclusions. Under that framework, why isn't the decision here to demote the officer from captain to lieutenant reasonable, given the circumstances here, where he has referred to women, he says that prefers two female officers not riding in in a car, in the same car. And he says that female officers might not be able to handle some situations because most of the female officers don't have upper body strength. And he says they need a male officer to help in a fight. And probably most significant is he says that these female officers would gossip. And so those kinds of things, why wasn't it reasonable for the NYPD to make the decision that they did?
Your Honor, it's very simple. In this particular case, it's a roll call situation in which
Well, it doesn't matter what situation it is. He's in a professional position. Roll call is part of his official duties. It's what he's supposed to do. And those statements are made. The real question is about substantial evidence.
I submit that the statements that are attributable to him has to be analyzed in the context of.
But they're not just attributed to him. He, in fact, did not deny the statements, right?
We're not denying it, Your Honor.
Okay.
Your Honor, the case of William versus the New York City Housing Authority set forth single comment or in any kind of comment has to be examined in a contextual basis. These statements were not made in a gratuitous manner. They were not made to disparage anyone, contrary to what the commissioner, the assistant commissioner of trial later used that as a basis.
Well, how else could they be made? I mean, to tell female officers for which you are in command of that you don't think that it's good for two of them to be partnered together because they wouldn't be able to handle the very job that they have been hired to do, and you prefer it to be another way because a male needs to be present. How is that not disparaging?
Well, the statements were not made in terms of an order. It is not characterized as an order. It is not characterized as any policy. In fact, it was never implemented. It was his view from the point of view of safety, tactics, in terms of car stop, what is the best way to carry out police functions. And it's almost like it's his opinion, his preference. And in fact, if you look at the entire record, no one was offended. In fact, that if you look at the record, the actual record, not the record.
I think what some of the female officers said was that they weren't offended because this happens so often. Not that it's not necessarily offensive, but they're sort of used to it, which is a sad statement.
Yep. But, Your Honor, with all due respect, citing the physiological differences between men and women is not in itself inappropriate.
Counsel, I think the main issue here is that this determination is supported by substantial evidence. This is beyond us. The question is only whether or not the determination that the NYPD made, this is an administrative agency's hearing, whether or not that is supported by substantial evidence. There's not really much to do here when that is the case. And we're arguing, this social science issue or whatever this is, but that's whether that agency, given its responsibilities, met the requirements under the law. And there was substantial evidence here.
I submit that there is no substantial evidence here. May I, Your Honor?
Do you want to address timeliness, whether your challenge was timely?
Yes, Your Honor. I believe that in connection with the issue of demotion, the police commissioner does have power to demote. There's a wide discretion, but it cannot be completely unfettered. In this particular case, his demotion was clearly predicated on the pending charge.
Isn't the process of demotion a separate procedure that wasn't implicated here?
It is not in this particular case in the sense that the police commissioner demoted him after he was inactive. He was not modified. He was not suspended. He was not restricted for over a year.
He was probationary?
Yes, he's a probationary captain at the time. However, as we all know, the police commissioner does not have the right to exercise that discretion by whim or because there was a pending charge of discrimination.
Thank you,
Okay,
counsel.
Renwick. I wanted to pose a question, but if not, I'll wait.
Why don't we wait till rebuttal?
That's what I'll do.
Thank you very much. Thanks, sir. Thank you very much.
Good afternoon. May it please the court, Karen Wolf for respondents. I will be brief and just pick up on the substantial evidence point the presiding justice brought up. As this court has noted, the review before this court is limited to whether or not the hearing officer had reasonable and plausible grounds for the decision. She did. Petitioner does not dispute making these remarks. He does not dispute making them in his capacity as a superior officer.
Right, but his position is that these were made in regards to safety and tactical decisions. That's his very job, right? To assign people or make assignments to consider safety and tactical decisions?
Certainly, safety and tactical decisions may be part of his job as the executive officer of the precinct, but this was his after-acquired explanation. And even then, he attempts to reframe his statements in the context of, well, it's for a tactical determination, but he couldn't offer what that tactical determination would be. His point is that a female officer was physically less than a male officer, and also that a female officer could be tricked or could be misled by a male suspect.
Or beat up, right?
Or beat up in the field. Unfortunately, that's probably true for all officers, and this is why officers have training and are armed. So his efforts to contextualize this actually just dig a deeper hole for himself because they belie, as the hearing officer found, this categorical discrimination against female officers.
Counsel, if I may, I won't wait to rebuttal. Now, we don't just have the petitioner's testimony. We also have officers Dale and Wong, and all of that testimony was consistent.
Yes, Your Honor, it was consistent, and those officers presented, testified under oath, and were available for cross-examination by the petitioner. So that's, this is perhaps the best form of testimony, eyewitness testimony subject to cross-examination. If I could just briefly move on to demotion,
Isn't that a separate track, the demotion?
Absolutely. Yes, Your Honor has my point right away, which is the demotion is not part of the proceeding before review before this court now. The demotion is completely separate. Petitioner could have challenged that demotion. In fact, he was invited to participate in the captain's probationary board process. He declined. He chose not to participate. He chose not to pursue judicial review.
So any challenge to that, that's waived.
That is time barred.
Time barred.
Yes, Your Honor, it's time barred, and this court has already made that determination in a case called Rocco v. Kelly, so that is well-established law. That is the crux of petitioner's complaint is the demotion, and it is no longer, it is not before this court, nor has it ever been before this court. And briefly moving to the actual penalty, which was imposed by the administrative law judge, that is a 30-day forfeiture of vacation days. 30 days of 30-day forfeiture does not shock the conscience. It's in fact less than what the department advocates requested. They requested a 50-day forfeiture plus a 1-year dismissal probation. The ALJ did not order that, but merely a 30-day forfeiture. So respondents would then request this court confirm. Thank you.
Thank you.
Your Honor, I submit that the way the evidence has been recasted by the respondents are not in conformance with the record. In fact, that the ADCT did not credit Dale's testimony, and that should be made very clear. And also, as far as the principal witness that the department relied on, Officer Wong, was not offended by his statement that women lacking upper body strength and preferably should not be paired in a patrol car. And we have to look
The
at
fact is that it's not just about Officer Wong, it's about women in general. He made the statement, so that's neither here
the
nor there.
statements were made in the context of tactics and safety. It was not made gratuitously. He was not attacking anyone. He was not disparaging anyone. And in fact, in the Williams case, single statement could be actionable for discrimination, for discriminatory conduct. But you have to analyze it on a contextual basis. And we have to look at his intent. We have to look at what happened. No one was separated. There was no order, no policy, no one, even from that point on, he continued to function as a captain for over a year without any restriction. And then right before, about a month after he turned down the offer of 55 days along with 1 year dismissal probation, the police commissioner then exercised its discretion and demoted him. Your Honor, there are cases in the first department in which if there's no record to support the exercise of discretionary demotion, how could he appeal on that? It's an empty record. He has to wait until the adjudication of the employment discrimination allegation. And I submit, Your Honor, you point out, yes, I am fully aware that
Thank you, sir.
substantial evidence gives the department substantial discretion.
Thank you.
And
We have your point.
thank you.
Thank you very much. Mosley versus RCPI Landmark Properties.
Good afternoon, Your Honors. May it please the Court. My name is Gabrielle Picard, and I'm with the law firm of Keller O'Reilly Watson, here today representing appellants RCPI Landmark Properties, LLC, Tishman Speyer Properties, LP, RCPI Holdco, LLC, and Schindler Elevator Corporation.
Thank you. So I'd like you to start by answering this question, which is why isn't this case governed by our recent decision in Garcia versus Monadnock, which is about to be heard by the Court of Appeals in March?
Sure. So,
And by the way, I mean, this is about a GWA case, right? A Justice of Injured Workers Act. And that case bars this retroactivity of the case of collateral estoppel and res judicata of the workers' compensation decisions. So what is left to be decided here?
So
We already have a decision here and waiting for the Court of Appeals to decide.
Understood, Your Honor. So, in terms of the Garcia matter, this one differs in that the workers' compensation decision states that no accident happened, not that the injuries are not causally related by what had happened. However, even with that, GWA really doesn't apply in this context because there's video surveillance that
First of all, it's the decision that doesn't, so it doesn't matter that they said it doesn't apply. It's the decision that they made that is not binding. That's essentially what it is. So that's just a different wording on Monadnock still applies.
Well, in terms of GWA, the Workers' Compensation Board here did not take a swift and cursory review of just strictly medical records. So whether GWA applies is actually not necessarily the issue at odds here, because the underlying motion was to amend the answer of the appellants and also dismiss the case because of the video surveillance footage and the Workers' Compensation Board decision, which is documentary evidence.
Isn't there a 4-second gap which leaves open the possibility that that's when the accident happened on the video?
So the employer was produced for a hearing in the workers' compensation proceedings, and they authenticated the records. And he explained the gap in the footage is that there's actually no movement at all that was going on in those seconds. So the resulting decision from the Workers' Compensation Board was that the video footage shows the entire hour span before, during, after, and the respondent herself testified that she did not fall. She didn't hear any noises, didn't feel like a roller coaster were her words in the workers' compensation proceedings. So the gap in time was explained that if there's any gaps in time, it's because there's actually no movement happening. So if I may continue to respond to as to why
You have 40 seconds to do so.
So here, whatever the outcome is in Garcia, there has been a full and fair opportunity to litigate the issue in the third-party action, which is whether the accident occurred. The Workers' Comp Board is permitted to serve as fact finders as to whether an incident even had happened. Here, we are not talking about whether the respondent's injuries happened because of whatever she alleged happened. They said that this didn't happen. So Garcia was a workers' compensation incident where they opined as to whether it was causally related to what had happened. Here, the contentions are nothing had happened.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Mona Patel on behalf of the plaintiff respondent, Charmaine Mosley. As Your Honor mentioned, GWA is appropriately applied retroactively here.
What about
because-
counsel's argument that this didn't happen? The argument at the workers' compensation is not a determination, it's that this didn't exist, that this just didn't happen, this accident.
Well, Your Honor, that is actually inaccurate because the Workers' Compensation Board found that there was insufficient evidence that an accident occurred. That is not the same as saying that no accident occurred here, or that the plaintiff would not be able to supply sufficient evidence to establish an accident occurred here. So therefore, the issue determined by the Workers' Compensation Board did not determine the same issue to be decided in the instant case in front of us. In regards to the motion to dismiss, the GWA Act was appropriately retroactively applied because, as this panel knows, in Garcia and Nunes v. CH Housing Development Funding Corp., it was determined that the legislature clearly intended GWA to be remedial in nature, and that it was correctly intended for unintended for judicial interpretation, and to reform what the legislature believed that the law should be, and that all aligns with the 4 elements or principal facts used to determine whether a specific legislature or statute should be applied retroactively. And so regardless of what any appeals court says about the Garcia matter, it's still legal precedent currently, and if and when an order does say otherwise, it is correct, GWA is correctly applied. And so like I mentioned before, collateral estoppel and res judicata does not apply here because the Workers' Board found that there was insufficient evidence, but not that there was no accident at all. And so based on...
Is it your argument that had they found that there was no accident at all, that then GWA would not apply?
No, that is not my position.
So it just applies to any findings and decisions of the Workers' Compensation Board?
Correct, and specifically if it was pending action, which this is, there is no final judgment in this matter yet, so it would apply. So based on that, we would ask for the relief that the court find that there was not an error by the Supreme Court and that the order was appropriately passed down and that it should be affirmed in all respects. Thank you.
So to respond to some of the points raised by respondent, the decision didn't say that there was insufficient evidence. The decision said the claimant's account of the accident is wholly refuted by the video footage. There was no occurrence as described by the claimant.
Isn't that a finding?
I'm sorry.
Isn't that a finding by the Workers' Compensation Board?
Yes, but that they did have enough evidence. I believe the respondent said that there was insufficient evidence to come to a conclusion. So
The point is that GWA applies to bar court from giving collateral estoppel to findings and decisions of the Workers' Compensation Board.
So as I mentioned before, they're concluding that no accident happened, and in addition
But
to,
isn't that a finding, as my colleague just asked? Isn't it a decision?
so
of-
there, it's a fine, go ahead, I'm sorry.
Isn't that a decision of the board? Isn't that the Workers' Compensation Board's decision?
So it is,
So if it is, if your answer is yes, then that doesn't apply, because GWA is applied retroactively.
well, GWA is applied retroactively based on the legislative intent where there's a swift and cursory review of medical records. So this decision considers the video footage and her testimony and medical records. It was not a swift and cursory review. It was fully and fairly litigated.
And
So
it's still a decision of that court. In any case, your time is up, so if you have any concluding remarks otherwise.
no, Your Honor, thank you.
Okay, thank you both. Lava Media versus Hart.
Good afternoon, Your Honor. Brian Brick for the appellant.
So if I might start with a question, I know that Hart had signed here a covenant not to sue.
That's right.
And then put the Lava in a difficult position when the day before the movie was supposed to be released, they sued in India.
That's right. And sought an emergency, like what we consider a TRO. It's the equivalent.
Here we are now, and the question I have for you is, and then, of course, Lava, you proceeded in the New York courts, but why was the lower court's decision in error where they just said to stay the New York action and allow the India action to proceed? Isn't what the court did consistent with the decision in 215 West 84th Street?
It is inconsistent. The reason why it's error is because what all of the cases that talk about stays require is that it's not enough just to have the identical parties. It's not enough to have overlapping facts or pieces of evidence, because you often find overlapping facts when the parties are also the same. What you need to have is an overlapping of the relief that's being sought, and in particular, the claims that are being framed. And there is zero overlap between what the case in India is about, which is literally a case only for the copyright infringement, and now for the related damages related to that.
So
Now, the
your
court-
position is that there can be no inconsistencies here?
That's
They're
right.
Absolutely separate?
That's right. No matter what the court in India decides, it will not impact the claims here, and certainly
You're really
can't-
following the framework of the decision in 952 Associates, where a complete identity of parties is required, and
well, there's a minimum of that.
the causes of action.
That's right.
As well as the judgment that's sought. That's what you're seeking here.
That's
But
right.
My question to you was, why wouldn't 215 West 84th Street owners be appropriate and maybe more appropriate? It's a broader decision, I would say.
Because
It's more
even-
broad discretion that's permitted.
Because, Your Honor, even moving away from a complete overlap standard, here, we don't even have any. There is no claim in this case that is overlapping with the case in India. There is no relief in this
Doesn't
case.
the Indian court have to decide as a premise, as one of the first premises, that whether the August 13 release was valid?
Well, that's not what the case is. That's not what the India court is being asked to look at. And
Is that something they're gonna have to decide?
no, all they're going to decide is who owns the copyright. That's all that the appellant, the respondent has sought.
So the August 13 release, covenant not to sue, is irrelevant in the Indian proceeding?
It is irrelevant. And in fact, Mr. Hart didn't even put that document in the record when he filed his action. What happened was, and they knew about the release since October of the movie since October of 2019. They waited till the day before the movie was being released on Netflix to file what was basically the extortive attempt to try to get a negotiation going. But the Delhi court saw that for what it is. That was in January of 2021. Here we are, 5 years later, and the case is still in the pleading stage. There have been, and this is why, the only reason why the lower court granted the stay was because they had the wrong impression of what the case in India really is. It is not in the discovery phase, as respondent has repeatedly claimed. And that's what the Addendum A from the Delhi High Court order shows. 5 years later, they are now on their 6th set of attorneys. They are now asking to change the complaint for the 6th time. They keep requesting adjournment after adjournment. So if we sit back and wait for the India action to play out, all of us will be gone from this earth because that day will never happen. 5 years, and they're still asking to change their pleadings. And in fact, it took an order from the Delhi High Court on the request from Lava and the co-defendants in that case to ask the court, please don't give them any more injunctions, any more adjournments.
Let's assume that the Indian court was being asked, to decide whether the 2013 contract was invalid, So let's assume that they were being asked that. And if they did say, yes, it's invalid, wouldn't that mean that the covenant not to sue would also be invalid?
I don't believe that the covenant not to sue would automatically fall if what they were doing was deciding rights in the separate settlement agreement.
That wasn't the question, and I can repeat it. The question was, let's assume that the Indian court was being asked to decide, is that release valid? And they said, no, it's not. Wouldn't that mean that the covenant not to sue would also be invalid?
I understand the question. The answer is it might, but that wouldn't impact the tort claims that are separately brought in this action that don't rely at all on the covenant, specifically the tortious interference with the Netflix relationship and the prima facie tort. Those two claims have nothing to do with, even if in that scenario the court was asked and did decide, none of that would still impact here. So most of this case would not be impacted by the India decision in that hypothetical, which isn't even the case. Thank you.
May it please the court, Your Honors, Peter Raymond for defendant respondent John Hart.
Counsel, do you agree that the Indian court, as a first premise, has to determine whether the August 2013 assignment to Particle was valid?
Absolutely, that and the other agreements before the court.
Okay,
and to determine who has the rights here, they have to look at all those documents and what happened after.
How do you respond to your adversary's position that, irrespective of that, there's still two causes of action here that are not implicated by that?
But they are, because the court in India has to decide what happened in 2013 and what it means. Did my client retain the rights, exclusive rights, to produce the movie version of this
Which, if they did, then there will be no tortious interference. Is that your claim?
That's correct. If they decided that, in fact, my client was correct and that they stole his rights from him after the fact, and that release signed in 2013. And by the way, they signed a release of my client in 2013 as well, but we believe that none of those are affected because of things that occurred afterwards, which is they fraudulently got the author to sign a First Amendment of the agreement that gave my client exclusive rights to produce by telling them my client had given up those rights. That agreement, the book rights agreement, clearly says my client and the author both have to assign any amendment of this agreement. That didn't happen. In fact, Lava's principal, Mr. Diora, went to Netflix and convinced them to produce this movie and convinced them that they had the rights to do it. And then they convinced the author to revise the agreement, all keeping John Hart, my client, out of this. He never did know what was happening. He was never.
I take it that you would agree that there is no complete identity here, and that the parties, the causes of action, and the judgments sought are not completely identical to that's being sought in India.
Not identical, but the Indian case completely subsumes the little issue in this case, which simply is that release binding. That as they've admitted, they submitted that release to the court in India, and it obviously didn't result in the Indian case being dismissed. So I think it's already been looked at, but they're looking at the overall picture, and that completely subsumes. This is like a malicious prosecution action brought in New York about a case that hasn't ended yet.
And what should we make of the fact that the movie was filmed in India, the transaction occurred in India, all the documents were executed in India, and the Indian court now is moving forward? It was delayed based on COVID, but they're starting to move forward, and counsel says we're not going to be alive by the time it finishes.
Well, that's why my client did sue in India, was because it's an Indian book, it's an Indian story, it was filmed in India, it's an Indian thing. sort of like Slumdog Millionaire, which they were hoping it would be as successful as, has not been yet. But so it makes perfect sense that this matter be in India rather than in New York, but that's not the reason why we think this should be stayed. It's just that that whole matter subsumes this matter, so that should be decided first. And Judge Adams, you know, she has broad discretion under 2201 to grant a stay, and she did that. They moved to re-argue, she did it again. So we think there's really no basis here to overturn that stay here when clearly the decision in India could lead, if you decided this little issue here, it could be inconsistent with what happens in India. It would be a waste of resources, judicial resources, and otherwise. So it's really sort of a classic case where a 2201 stay makes sense for all parties, we believe. So unless the court has anything else.
Thank you.
Thank you.
What's incorrect is that this is all cited in India. The agreements were not signed in India. They were actually signed in New York by a number of the parties. There is a New York choice of law clause and a New York dispute resolution clause. So this fact that this is the situs of India is only because Hart and his co-plaintiff ran to India on the eve of the release to do this. They should have come to New York because that's what the agreements say they should have done. There's a provision for jams mediation and arbitration in New York. But they didn't do that. They ran to the court in India. And to say that this case hasn't been dismissed, it hasn't gotten to the point where it could get there. The defendants in that case have a pending motion to dismiss based on procedural and jurisdictional issues that has been on hiatus for a year while the plaintiffs have requested adjournment after adjournment and have switched lawyers. So that case will be dismissed for jurisdictional and other reasons when it actually gets to that point of being able to have those considered. But intentionally and by design, the plaintiffs in that case have brought the action to a standstill. So it's not accurate to say that the case is now moving forward in the post-COVID world. The case has sat for 5 years in the post-COVID world. And in fact, 1 year since the stay has been granted, because the stay was granted by the lower court in January of 2025. Here we are, January 2026. Not one thing has happened to move the case in India forward except requesting new lawyers and new adjournments. So that is really part of the problem here, is that there is just an inconsistent factual basis that's being given about the two actions. And to say that the tortious interference claims would fall based on the covenant is also inaccurate because it also has to do with the timing of the lawsuit. The plaintiffs in that case knew in October of 2019 that Netflix was working on the movie. 2019, 2020. They waited till January of 2021 to file on the eve of it, something that the court saw so transparently through that they didn't even request responding papers from our side. They just denied it based on the oral hearing that they had. So in this case, the stay is not appropriate, and it was an abuse of discretion, and we would ask the court to overturn it. Thank you.
Thank you. Thank you both. People versus Lonzell Green.
Good afternoon.
Proceed.
Allison Haupt on behalf of Mr. Green. At minimum, Mr. Green is entitled to resentencing in his 2020 case because his defense attorney had an actual conflict of interest at sentencing. To justify a doubled fee rate, counsel presented facts that—
Don't you need a 440 hearing for that?
No, Your Honor, all of this is within the record. We have the motion that counsel filed with the court that lays out all of the damaging facts that he shared about Mr. Green, that he was a difficult client, that he showed great disrespect throughout the case, including at the time of sentencing, that he used profanity, refused to adhere to courtroom decorum, engaged in bad behavior too many times to delineate here, and so on. All of this is in the record of this case. And so that's the epitome of a conflict of interest. In order to represent the attorney's
But he
desire—
asked for there were issues that weren't. I mean, you really have to have the full hearing on that particular issue to ensure that you have all the facts. I don't know that there was any discussion as to enhanced pay. or the counsel's relationship with the defendant. Um, I don't know that the court had an opportunity to review or consider those issues before imposing sentence.
Well, we know that the court reviewed it because she signed that order for enhanced fee on the same day as sentencing.
But those issues weren't addressed in it.
Yes, they were. The motion that counsel filed with the court included all of this disparaging information about Mr. Green. So at the same time that the court had to decide what's a fair sentence for Mr. Green, it had information that was confidential, only obtained during the attorney-client relationship that was disparaging. The sentencing analysis, of course, is looking at Mr. Green's personal status, his character, his background. His attorney revealed confidential information that was negative and disparaging about Mr. Green in order to benefit himself by getting a higher fee at Mr. Green's expense at sentencing. And here, People versus Jean-Baptiste, a case recently decided by the court, is directly on point, where the court found that prematurely sharing confidential information that went beyond the scope of what was necessary, that's an actual conflict of interest. And that's what we have here. There was no reason to file this motion in advance of sentencing. The court didn't even decide it until the day of sentencing.
There was an entire trial here. So doesn't that have to be viewed in this context to make a determination as to whether what happened during the trial was influenced at all by what the defendant said about the defendant before?
What we're asking for is a new sentencing hearing because counsel revealed disparaging information about Mr. Green.
I understand that, but you have this entire record that the court has reviewed in order to impose sentencing.
There's nothing that a hearing would be required here. The question is, did the attorney reveal confidential disparaging information at a time when he owed an obligation to Mr. Green? And we have all of that in the record. We have the disparaging information.
So your position is that well, not maybe it's your position, if he had made these statements or this representation in the context of wanting to be relieved as counsel, no conflict. But because he continued on and represented him through the sentencing, there was a conflict there, as my colleague pointed out, notwithstanding the trial and everything else that came before that?
Well, Jean-Baptiste says that the scope of what's being revealed is at issue. So I don't know that even in the context of being relieved, that sharing this level of disparaging information would be appropriate. But certainly here, he's staying on as counsel.
So he shot this woman. I mean, they're at a party, an outside event. Somebody speaks to him. They have a conversation. He knows these people. He goes up to his apartment and he gets a weapon and comes back down and then shoots, tells the woman, "I'm going to kill you," and shoots and hits another person. And the sentence ranges 10 to 25, I think, and he gets 13, 3 years over the minimum. And the evidence here, you're saying, that was included in this request for greater fees impacted the court because the court would have given the minimum here, or 11 years, or 12 years, or something less than the 13 years that was given here.
Well, when there's an actual conflict of interest, prejudice is not considered. So the question is, a court considers more than just the offense. They also consider the offender, their background, their personal status.
Would the issue of the actual conflict of interest be something that would be flushed out in the 440 motion?
The issue here is...
Because we're talking in very conclusory terms right now, right? Wouldn't we need more to determine that, or do we need more?
We don't need more, Your Honor, because we know that this was confidential information.
It's confidential that the client was difficult?
The attorney spoke about their communications with each other, their discussions about motions, talking about behavior.
Speak about the substance or just saying that the communication was disrespectful?
He talked about the substance of some of the conversations, but even saying that
Like what? Be specific.
He talks about asking for baseless dispositions. He talks about demanding motions that he doesn't think that are appropriate, but confidential information
But these were motions that were made at trial.
throughout the pendency of the
And
case.
you're
or motions
saying
that he
that part of
wanted.
it is not relevant, but he's talking about motions that were made at trial. One would have to go to the trial to see what he did to determine the value of anything that was said and whether it was impactful. I mean, that's why the 440 is necessary, because there are things that he said that one, if they were really reviewing this thoroughly, would go back to see, because you just said that they were baseless. And he's saying that he's making all of these motions and it's difficult and everything else, but what kind of representation did he provide throughout that entire process?
But this isn't a question about effective assistance. The question is, did he share confidential information is something that would be damaging or embarrassing to a client that you learned during the pendency of the attorney-client relationship?
Aren't you talking about the defendant being deprived of effective assistance of counsel?
No, it's
By a
that there's
conflict of
an
interest?
actual conflict of interest that acted upon sentencing, that he had an attorney who was supposed to be arguing for him, arguing at
You're saying that this client was deprived of an effective assistance of counsel because there is an actual conflict of interest. That's what you're saying. But you are asking us to do that just on the statements that were made. But those statements, it seems, go back to what happened in the trial. You're saying that because he said those statements, there is a conflict of interest. But they are about things that he did during trial. It seems that those would have to be reviewed to really determine whether or not that's the case.
I think the existence of the information is alone, it's in the record. But if I may also, we do have another issue that
I'm going to let you address that on rebuttal.
thank you.
May it please the court, Alexander Michaels on behalf of the people.
Counsel, why not wait till after sentencing to ask for a raise?
I'm frankly not familiar with the logistics of these particular kinds of motions, so I don't want to opine too firmly on how it should have been done, but...
With that said, why is your adversary wrong that instead of advocating for a lower sentence, he's telling the court, my client's a jerk?
So the comments he makes in here are about his client as a client, right? He's saying that this is a difficult case
Yeah, but
involving
it's
a demanding
disparaging, no
client.
matter how you slice it, right? He's not saying my client's a good guy. He's here charged being found guilty of pretty serious crimes, and then on top of it, he's pouring onto his client, and he's not a good guy. He's disrespectful to me. I want more money because of that. Wouldn't it have been more appropriate to wait for sentencing to then make this?
It may well have been preferable to do so. Again, I don't know about the
Isn't it
logistics.
possible that this information that's provided by counsel swayed the judge in some regard?
The record really
Despite
doesn't...
the fact that, as my colleague stated, the crimes here were it was horrendous, right?
The crime was absolutely horrendous, and it's a remarkably favorable sentence that he received, given how horrendous the crime was. But what you can see here from the record is that the sentencing court, having presided over the entire trial, being intimately familiar with the particulars of this case, intimately familiar with the victim impact statement and the PSR, all of which she mentioned during the sentencing proceeding when explaining the basis for her ruling. She also alluded to all of the letters of support written on defendant's behalf before issuing her determination. She didn't mention anything about a motion for enhanced payment.
How does the John Baptiste case that your adversary has mentioned numerous times, how does that affect your position here?
So the comments in this case are nothing like the comments in Jean Baptiste. In that one, I looked at the briefs. The lawyer had gone up to the court, ex parte, and said, my client wants to testify. I know he's going to be lying because he's confessed to me that he, in fact, committed the crimes with which he's...
That would be confidential.
Yes, that was very confidential. The trial was ongoing. And so the lawyer also did not need to get into that in order to explain why he wanted his
That's an
client...
understatement.
Excuse me?
That is an understatement.
Right. The lawyer did not need to get into that. This was volunteered unnecessarily, and this went to the absolute heart of the matter that was presently being litigated. Here, we have a lawyer talking about how the client is difficult. This is a lot like many comments that this court has reviewed in the context of motions to be relieved as counsel or requests for new counsel.
And
Lawyers-
the fact that the lawyer continued to make these motions and felt that he was working with a demanding client who wanted to make these motions, isn't that evidence that he was a zealous advocate, that he was doing what his client wanted?
Absolutely. It's not clear exactly which motions the lawyer had in mind when he was referencing this stuff. Frankly, these are sort of vague and conclusory statements in the motion itself, the motion for enhanced payment. It's also sort of hard to follow what he's saying at certain moments because the list is sort of jumbled together. But that goes to the fact that these are not really damning specific claims about this particular client. Definitely don't go to his culpability for shooting somebody. They go to whether he is in fact a difficult client. And of course, being a difficult client does not warrant getting an enhanced sentence.
But we're at the sentencing stage right now, right? And so in the sentencing stage, the court is not just looking at the crime, but maybe other things as to what's the sentence going to be. And so why isn't it the fact that maybe he's difficult and he's been disrespectful, or how does that weigh in at all?
Well, the court surveyed numerous things that she had considered in relation to this. And she didn't mention defendant's conduct in court in any way, didn't mention defendant's counsel's account of his conduct in any way. None of that seemed to factor into the court's decision whatsoever. Unless the court has any questions.
I do have a question about the YO adjudication or lack thereof. Why wasn't a YO adjudication on the first conviction here appropriate?
So there's a plea agreement. It was a plea bargain, meaning that people had dropped the top counts in this case. And the agreement was for the defendant to receive the particular sentence that was not a YO sentence. Then at the sentencing, the parties had the PSR as a...
Was a recommendation for YO, wasn't
the PSR mentioned in conclusory fashion, YO recommended.
And then the court, in a very also conclusory fashion, said, I'm not doing it.
Well, not exactly, Your Honor. What happened was the court asked the parties if there was anything in the PSR that warranted revisiting the plea agreement. And both parties said no. First, the people said no, and then the defense said no. And this is at the very initial sentencing proceeding back in 2015. The defense said no. The defense did not ask to revisit the plea agreement, the terms of the plea agreement, based on that recommendation or any other ideas about.
In your view, did the court satisfy its obligation to state on the record its thinking with regards? Yeah, basis. Thank you. With regards to the YO.
Well, there was a Rudolph problem with that initial sentencing, and that's why there was the resentencing here. So yeah, there's no question as to that. I think what we did was we consented to the resentencing via 440-20 motion, even though that's technically not the procedurally proper.
So why shouldn't we exercise our own independent discretion power to grant YO?
Well, the resentencing court thoroughly reviewed all of these factors, right? There were extensive submissions. The resentencing court got into all of this, held a hearing from both parties about the underlying crimes, about the various things that have happened since then. But numerous factors demonstrate that that the resentencing court providently exercised its discretion in not awarding YO treatment here.
Well, us exercising our power doesn't necessarily mean that we're saying
that. Sure. And I'm happy to list the factors now. One major one is that a subsequent reoffense counsels strongly against YO treatment at a subsequent resentencing. And this court has specifically held that, and I think the name of the case was Ortiz, and I believe the presiding justice was on that panel. Also, we're talking about 4 different violent crimes underlying the original 2015 convictions. Not talking about the subsequent shooting, just the original ones. 4 different violent crimes. One was a gang assault that culminated in a shooting. Another was a gang assault.
That was all wrapped up in that plea, right? Those 4 incidences. But before that, the defendant did not have a criminal conviction.
No, before that, no. But there were 4 different offenses. There were 2 criminal convictions. The 2 criminal convictions came out of these 4 different offenses. 3 of them were gang assaults, and 1 of them was a criminal possession of a weapon. Now, I note that the criminal possession of a weapon, of course, is also an armed felony. That would trigger further inquiry into whether there was, if the people had insisted on a plea to the criminal possession of a weapon charge in order to avoid YO treatment, for instance, that would be presumptively ineligible for YO treatment unless there were some mitigating factors. Given the number of underlying felonies here, and again, the subsequent reoffense in even more dramatic fashion, YO treatment was thoroughly inappropriate. I would also note that those number of underlying incidents spanned 19 separate months. So we're not talking about one isolated outburst or anything along those lines. We're talking about repeated outbursts over the course of more than a year and a half. Thank you, Your Honors.
Picking up on that, Lenzel was between 14 and 16 years old at the time of this. Only one of those offenses was he even 16. He was primarily 14 and 15 years old, and well aware of the number of instances where he was lured by older men in the community. The probation department knew about all of that and still recommended YO. The judge did not consider YO at all in 2015 when it should have. And it's important to think about YO at that space and time with that child at the point at which probation recommended YO. And it's important because that's the juncture where we should consider, would YO have been
Well, what should we make of the, well, your adversary just said that the defendant was given an opportunity to tell the court why it should, do otherwise with regards to YO and didn't, and failed to come up with proffer any reasons.
This is a 2015 case. It's after Rudolph. The obligation is with the court to consider YO, and they did not consider YO as required. That is not, Mr. Green should not be held responsible for that. It's a requirement of the court. And the factors here, this child, we outlined in the resentencing submission, the difficult childhood that he had, the reasons why he was lured into this gang, probation recommending it. And it's impossible to not look at the road not taken. Had he not served all that time in adult prison, what would have come of Lanzel? And now we get to see that, how well he's doing without any disciplinary tickets in prison, in the barred prison program. The court speaking really admirably about him, how articulate and bright, and how much he accepted his acceptance of responsibility. With all of this, this was a childhood crime. That crime should have been given YO, and we would ask that you do that here in this case. If I may just also, it was error to not submit the lesser included offense to the jury. All that was necessary was some identifiable basis within the evidence to believe that this was a physical injury and not a serious physical injury. And here, medical records would have supported that this was a physical injury. Yes, there was a wound, but the medical records show that in time, pain, she wasn't feeling pain.
It was protracted. I mean, one of the things you have to show for serious injuries is protracted, and her injuries lasted quite a long time. In fact, by the time she testified, she was still suffering stiffness and mobility issues.
Well, the jury had the right to question the credibility of her testimony on the stand by referring to the medical evidence. This court doesn't have to agree. This is not weight of the evidence review. You could all look at this evidence and say, if I were on this jury, I would convict of first-degree assault. But the question is there some identifiable basis in the light most favorable to the defense where a jury could have looked at this evidence and said, you know what, I think that maybe she's exaggerating a little bit. The cases that we have in our briefs, it's not as if any amount of pain, if you have it at the time of trial, that necessarily makes it a serious physical injury. And we go through that even feeling pain in a scar that lingers or...
Well, this was a little bit more than that. I think there was evidence that one of the bones was pushed so that it shortened it, and then this was, I would have to find it, but I think you're aware of what I'm saying, that this was just more than, oh, there's a little burning or a little, there was a real difference in the mechanics of her arm after that.
I don't think that the medical records come out and say that. There was a question about whether there could be this impaction. No doctor spoke about what it actually did to her. A doctor testified about generally what that term means. And the medical records show that she wasn't even taking over-the-counter pain
Well, he said there was impaction.
There was a medical record.
Then it was described. Then it was defined.
But there was no information. There was a request for a CT scan to look into this impaction. There was some, I think they describe it as an impaction or something else, but no fractures. There
doesn't have to be a fracture. A fracture is now something else, for sure, a fracture. But this wound went through and, through muscle and everything else, and she describes, I understand what your argument is, but
the burden here is quite low, though. If there is some identifiable basis to think that based on these medical records that the pain had decreased, that she had greater motion of movement, that she...
It says, actually, in the People's Exhibit 17-200, that a CAT scan revealed an impaction deformity of the humeral head.
But there was no... We don't know if that went away. We don't know what came of it. We don't know how it impacted her arm. We know that her range of motion had gone to much greater in October and in September, that she wasn't in pain. These are things that the jury had the right to decide. If this court would decide otherwise, that's
They
not
had
the
that
standard.
before them, and if they thought that it wasn't protracted, they could have acquitted.
But that's not the standard here. The standard is should the lesser included have been offered to them. Maybe they didn't want to completely not hold them accountable for the shooting.
Argument. Thank you,
Thank
counsel.
you.
Thank you both. Floor 138 versus Goldberg.
Madam Presiding Justice, and may it please the court. Every day in New York, millions, tens or hundreds of millions of dollars.
Counsel, I'm going to ask you just, what is your basis for demanding prejudgment interest on, in this case, on the released escrow monies where the escrow agent's referral to release the escrows over the objection of the other party conformed with the escrow agent's requirements under 14C and D?
Absolutely did not conform to the requirements. So let's talk about the language of the agreement. The way it works is...
So in 14C, it says that if the defendant received a demand for the release of the deposit from either party, it was required to deliver the letter to the other side, and the other party shall have the right to object to the delivery of the deposit.
Correct.
By written notice of the objection delivered to the defendant within a certain number of days of the receipt of the demand from the defendant. The defendant would then deliver the objection to the party seeking release. It also says in 14D that a final order of judgment is entered with respect in the event that the escrow agent shall have received a notice of objection as provided for in C, the escrow agent shall refuse to comply with any claim or demand and continue to hold the deposit.
Yes, and that's exactly what happened, but it goes on and says, shall continue to hold it until.
Two, a final order or judgment is entered with respect to the delivery of the deposit, in which case the escrow agent may then deliver same in accordance with said order or judgment.
Okay.
Within 30 days of a judgment, it was released.
No, it was released 2 years after the judgment. The judgment was issued by Justice Crane in 2018.
There was an appeal of this, wasn't there?
Yes. Now, this agreement...
And following the appeal, wasn't this released within 30 days?
Yes, and that was 2 years too late.
Excuse me. Was the money released within 30 days of the appeal, the decision and judgment?
It was, but let's be clear, Judge, okay? Many times you see an agreement which says that the money will remain in escrow pending a final, non-appealable judgment. The parties have contracted in that case for the monies to remain in escrow pending an appeal. Here you have sophisticated business parties that don't want this money, regardless who wins or loses, don't want it sitting in an escrow account earning little or no interest.
Counsel, I'm just reading the document, and I don't see anything about a final order after a trial, or a final order after a Supreme Court, or a final order after appeal. It says a final order or judgment.
Yet final judgment means a judgment that determines all the rights and obligations of the party. It does not, this is so clear. In fact, they've abandoned the argument that this was not a final judgment. Final judgments are issued by the court of original jurisdiction that resolves all the issues between the parties. That's a final judgment. In fact, the very document that Justice Crane issued is titled Final Judgment. This was a final judgment. At that point, the escrow agent was required to release the money. And if it had any doubt, then it had the option to put the money into court, and that would have enabled my client to get the money immediately.
Would the language notwithstanding any appeal taken have to have been in there to have it to be more so clear?
I'm sorry, please repeat that.
The language notwithstanding any appeal taken, would that be necessary to make it even more so clear?
Yes, there's no reference to an appeal. The only reference here is to a final judgment. And unless this court is going to create new law and say a final judgment only becomes final when it's affirmed on appeal, and that would be unprecedented, the event that triggered the obligation to release was when my client won in the trial court. If the parties wanted to say, and it shall remain pending conclusion of all appeals, they could have said that, but that doesn't make business sense because these are real estate investors. They make 30, 40% on their money conceivably, not 0% while it's remaining in an escrow account. And I just want to point out.
Thank you. You can point it, we have your point. You can point it out on rebuttal.
Good afternoon, Your Honors. Matthew Hurl for Goldberg Weprin.
So, counsel, if appeals weren't to be taken into consideration, should that language have been in there? And if a judgment isn't final upon, as your colleague says, when it's entered by the court of original jurisdiction, what does that mean then? That anytime someone doesn't want to adhere to that judgment, they just go and file an appeal and then now it's stayed?
Well, there's a couple of layers to that question, Your Honor. The trial court did issue a decision and a judgment that said that his client won and were entitled to the deposit. However, this provision allowed for, it never took away the discretion of the escrow agent to ensure that it was not releasing the money prematurely or wrongfully. We received an objection from the party that lost at the trial court.
Based on what, counsel, when it's, because if your adversary is correct, that final judgment means that what's issued by the court of original jurisdiction and it doesn't incorporate an appeal, then there's no discretion.
Well, there is discretion, Your Honor, because the agreement provides us discretion.
But what is that discretion? Because it says upon final judgment. When I don't understand the word may, why is that there?
Well, may, because we had the discretion. If there's continuing objection to the release of the escrow by the party that lost and was pursuing the appeal, it was not only appropriate but incumbent upon us to hold that money pending the appellate division decision. We retained the discretion to, if there was an objection, to not release. The counsel is reading into that shall as opposed to may. If, as he said, sophisticated parties negotiated this. If this money was to go as soon as the trial court decided, it would have said, you shall release the deposit. It said, you may.
And it
Because
says-
we are.
And it says after the may, then it says, and the escrow agent shall not be or become liable in any way or to any person for his refusal to comply with any such claims or demands. And it goes on from there.
Correct, Your Honor. This whole provision is to protect the escrow agent from claims where it is exercising its discretion in conformity with these provisions. And remember, this is all coming over an objection. That's the fundamental thing. So we, as the escrow agent, are insulating ourselves, and the parties insulated us.
So if what they wanted is that if there was a final order from the court of original jurisdiction and you had to disperse then that may should have been a shall.
Absolutely. Absolutely. But again, it was may because we're overriding one party's position. One party is saying, don't release that.
Right, there's an objection.
And there's an objection. And as escrow agent who has no dog in the fight, we are trying, and the parties
You're just trying to get it right.
We're just trying to make sure that this gets resolved the way it should. And
Because then if you had released the money and it would turn out to be an error, we'd be here on something else.
Because the other party would have said, we objected, and you ignored us.
And they would have said, you objected, we had an appeal to the first department, and the first department said I was right.
So instead, you
know
wait
what
for the
we'd be
first
getting?
department to decide, and then you disperse 30 days.
I would have Tissopet against Goldberg Weprin here saying you released the deposit over my objection.
And didn't they have to prove that you were grossly negligent or it was a willful default for them?
That's the whole nother level of the thing is we're not supposed to be liable for anything, and we had to be grossly negligent. And I submit to you that this is this happens every day. Escrow agents cover their tookuses a lot. And so they don't release money unless the agreement requires it or a court tells them. This court said, Tissoped lost, and within 30 days, we released the money to them. And Justice Bannon saw it, and she threw this case out, and we asked that this court affirm.
Thank you.
Let's be very clear. The word may in this context doesn't mean may or may not, that they have discretion. It means they were previously barred from releasing the money because there were competing demands. At that point, once there's either joint instructions or a final judgment, they may then release it. They can now do something that they were
What happens to the
unauthorized.
part after that? It says, may then deliver the same in accordance with said order or judgment. And the escrow agent shall not be, because it says may first, so may means they don't have to, but shall not be or become liable in any way or to any person for his refusal to comply with any such claims or demands, or in the event the escrow agent shall receive a written notice signed by either a signer or assignee advising that litigation between a signer and assignee has been commenced. Why doesn't that make your argument frivolous?
I'm going to show you why. Because it says such claims, refusal to comply with such claims, that tracks the exact language earlier, which says the escrow agent shall refuse to comply with any claim or demand. That's the original ones. And then what it's saying is if you now follow this agreement and you release the money as you are required in accordance with the judgment, it says you may then release it in accordance with the judgment, you will not be liable for the refusal to comply with such claims. That's the claims earlier in the paragraph.
Now, counsel, the language in the, excuse me, thank you, the language in the agreement did not condition the release on the judgment being non-appealable, correct?
Correct.
I have another question.
Sure.
Another question. This language, it did not indicate that a refusal to release the monies while the appeal was pending, that would be a willful default, right?
Well, the presumption...
No. Listen to the question.
I heard the question.
No, I'll repeat it for you.
Sure.
The question is, the language did not indicate that a refusal to release the money while an appeal was pending, that would constitute a willful default.
It didn't have to say, it didn't say that, but it wouldn't have to because it said final judgment.
I understand.
I just want to point out one thing. You know, you have very smart lawyers here, but this case was framed by the pleadings. There's an admission in the pleadings. Admissions are binding. Paragraph 40, it says, defendant, that's Goldberg-Weapon, admits the allegation in paragraph 40 of plaintiff's complaint that defendant is required to disperse the escrow funds upon a final order or judgment, but denies that defendant is obligated to do so because the decision and order was not final because they preserved their appeal. They didn't say they didn't have discretion. They admit in their pleadings that if there's a final judgment, it must be released, and a final judgment was issued.
Thank you very much.
They put this appellate gloss on here, which doesn't exist in the contract.
Thank you. Thank you both. Butler versus Marco Realty.
Good afternoon, Your Honors. May it please the court. I represent Marco Realty, Gap, and Old Navy, as well as James Hunt Construction in this personal injury labor law case. This is a case where plaintiff alleges a pipe fell from the ceiling and hit him, and our appeal is based on finding reversible error. From the start, it should be noted that plaintiff's inconsistent testimony as to the circumstances of his incident, including the presence of others in the location of the accident.
Okay, that doesn't matter. We're talking about a pipe that was 8 inches by 10 feet long or something like this, and it fell and it hit him, and I don't see, without a safety device, how that is not within 240 sub 1.
Your Honor, in respect to that, Labor Law 241 is in regards to any accident which occurs relating to an elevation-related risk. And this
When something falls, what is that?
In this situation, in this circumstance, plaintiff was working in a subcellar. He was digging a hole. He
It doesn't matter what he is doing. He is working in an area, and something in that working area falls and hits him on the head. You don't think that that is a 240 sub 1?
In that specific area where he was doing work, no one knew that there were any pipes above him. There was no notice to...
No one knew that there were pipes above him?
Is notice part of the 240 sub 1 framework?
There was no, besides from notice, there was no...
So timely that we should hear this construction during this meeting. Oh, my. Sorry.
Perfect for me, no. It was not foreseeable that a pipe would have fallen. Labor Law 241 requires that there be a foreseeable circumstance in which something falls from a height. In this situation, in this situation, we're saying that there was no work which was ongoing above plaintiff. It was a subcellar. The building was being demolished. There was a
Was
demolition.
someone cutting the pipe?
No, Your Honor, there was no one cutting the pipe. Specifically in this scenario,
The
plaintiff was
plaintiff
digging a hole.
testified that someone was cutting the pipe and they stopped when he got there, when they came into work. And there's nobody to dispute what he said. And he says, and then the pipe fell down. And so I'm not quite sure, maybe you should move on to the next argument because that argument is your 240 sub 1 argument, correct?
Yes, Your Honor. And just in respect to that matter, one more thing is that let's say there was ongoing work with where plaintiff was working, that would be a different situation. In this circumstance, there was no ongoing work.
Does the work have to be ongoing at that time? The fact that there was work being done, and we're talking about there a secure safety device, right? Was there a safety device securing the pipe? It fell. No, so there wasn't. What else is there left to decide?
The pipe was hidden. No one saw it. There was no work going on. You know, plaintiff's testimony has been consistent throughout the record.
The man was hit
but I will move
by
on to
a
mine.
pipe. The pipe fell from the ceiling. He said he saw someone working on it, cutting it. So we can't say no one saw it, it wasn't there, it hit him, the pipe exists. So there's your 240 sub 1. There was nothing keeping it up there. I'm not quite sure.
Plaintiff's testimony was that there was someone from the general contractor named David who was working on the pipe. However, the general contractor provided testimony that no one was working on.
You're not arguing sole proximate cause here?
Well, the sole proximate cause also was the fact that plaintiff, you know, if he did see
You're
someone
arguing that
working
this didn't happen?
I'm arguing that there's definitely plausible, there's definitely a situation where it did not happen. Yes, that's what I'm arguing. That it's possible that plaintiff created it, there was no one around, you know.
You mean
Isn't
that the
there an
pipe was
accident?
already there and he said that pipe fell on me?
He was saying, his testimony was inconsistent throughout the record. I took his deposition, there was testimony which I'm sorry, I'll move on to mine.
Isn't
I
there
think you
just
should.
an accident report that is consistent with his version of what happened?
The accident report, you know, it's just provided from plaintiff's narrative as to what happened. There's no one else who said that that's what happened or that corroborated
Do
that.
we need eyewitnesses to these accidents in order to make them credible?
I mean,
Is that what our case law says?
it doesn't say that, but case law says, you know, in other situations under Labor Law 241, where things fall from above when someone is working and there's no above head work, that there is a possibility that, you know, it could be.
Except that he said somebody was working on it, and there's nothing to contradict that. You have less than 2 minutes.
Yes, as in regards to Labor Law 200 and common law negligence, we're saying here that the general contractor and the owners of the building, they had no notice of any conditions on site. Furthermore, we're saying that.
This is a means and methods case?
So we're saying that plaintiff's means and methods were the reason for his accident, and therefore, in regards to our next argument regarding indemnity.
Plaintiff's means and methods?
The plaintiff's employer's means and methods, always first. And we're
Your
saying,
clients were not involved in the means and methods of the work here, correct?
yes,
You're the
correct, Your Honor.
owners,
Yes, the owners and general contractor, and so
including
in
John
regards to that-
Hunt, including James Hunt.
James Hunt Construction, yes. And in regards to that, we're saying that James Hunt Construction, at the very least, should be entitled to indemnification in common law.
James Hunt, if anybody, was the one who would have been controlling the trades here. So there is a potential negligence against James Hunt. So how is he going to be excluded from this?
Yes, Your Honor. I'm sorry, I confused the names. I meant to say Marco Realty. Marco Realty, as an owner, there's no evidence that they had any fault regarding this. Furthermore,
Just to be clear, because I think I got confused a little bit, you do not represent James Hunt.
I represent James Hunt Construction and Marco Realty.
All of the owners.
The owners and the general contractor.
So are you saying that the owners and the general contractor, James Hunt, there was no part of the means and methods?
Yes, they had no part of the means and methods, and we're saying because of that, they're entitled to contractual indemnification under the very broad language which provides that if the accident occurs arises out of the work in which the plaintiff was involved in, then.
Except that you can say that about the others, but James Hunt is the one who would have been responsible as the GC for managing the trades there, consistent with what the gentleman said. And I lost my train of thought. And
That would make him responsible for the means and methods.
right, thank you.
The employer isn't responsible for the means and methods. The general contractor does not direct it.
But James Hunt was the one that would have, according to the plaintiff, James Hunt would have been the one that would have scheduled the person cutting the pipe on top and scheduled him on the bottom excavating the concrete, right?
Right, which James Hunt specifically said that they were not, that there was no one working on site at that time, and that
Okay, at this point, there is still a question of fact as to whether James Hunt controlled those trades and whether or not this was a result of their negligence. Your time is up. Let's have somebody else.
Good afternoon, Your Honors. Travis Wong for the plaintiff respondent. I'd just like to note that the appellant made a couple arguments that weren't in their papers, namely about the inconsistency and that the accident didn't occur. Basically, on appeal, defendants only argued that this labor law doesn't.
Your argument is that your client should be granted 240 sub 1 because he said somebody was cutting and it fell down and hit him.
Yes, I will rest.
And there was no safety device.
Yes, if you have no questions, I'll
I
rest
think
on
we
that brief.
understand that argument.
Thank you.
Good afternoon, Your Honors. Kevin Hickman on behalf of Always First. The only thing I want to point out is that the contractual indemnification provision in my contract doesn't have the relevant savings language. So it purports to indemnify James Hunt for its own negligence, which, as Your Honors pointed out, there's an open question as to whether that's applicable here. So if you don't have any other questions for me, I'll rest on my papers as well.
I don't. Thank you.
Thank you.
Good afternoon, Your Honors. Gregory Lewis for the respondent, QCC Maintenance. Very briefly, we submit that the contractual indemnification claims are not applicable here for the following reasons. First of all, it's already been alluded to. There's a question of fact as to whether James Hunt was negligent. We have the testimony of the plaintiff that it was one of their employees who in fact cut the pipe. We also have the testimony of Mr. LaPuma on behalf.
QCC was the subcontractor responsible for pipe removal?
There was a provision in the contract, Your Honor, that they removed the pipe, but in this particular scenario, there are questions of fact as to whether they did remove it for the following reasons, as I just indicated. Number one, the plaintiff himself testified that it was an employee of the GC, in this case, James Hunt. He described him as a gentleman by the name of David, a black man, who had been cutting the pipe.
But the bottom line is QCC would still be in the case because there's a question of fact as to whether or not QCC's employer was the one cutting the pipe or had anything to do with that.
Well, the question here, Your Honor, is whether they are entitled, James Hunt and the other defendants are entitled to indemnification. And here, there certainly are questions of fact as to that because, as I indicated, our client, Mr. LaPuma, testified, and it's actually supported by the testimony of James Hunt's own supervisor that his employees were not even on the site that particular day. They had finished their work 1 month before this particular incident occurred. There's no indication at all that they were ever called back to do work pursuant to a punch list. And you have, as I indicated here, the unequivocal testimony of Mr. Hinton, the James Hunt construction manager, that our employees were not there. So there's no way that this particular incident arose out of the actual work that was performed by QCC Maintenance. So based upon that, those three arguments, if I may use baseball vernacular, 3 strikes, you're out, okay? So I will rest on that.
And in response to that, we are saying that the motion court should have awarded summary judgment to appellants on their contractual and common law indemnity claims against QCC and Always First. At the least, I'm saying that there should be a minimum of a conditional grant of indemnity against Always First because they were the employer. Furthermore, there should be a conditional grant of indemnity against QCC because Their own witness admitted it was in the scope of their work to remove the pipes. Furthermore, in the record, there's evidence which provides a record which shows demolition keynotes from the general contractor, which provides that QCC was required to remove all abandoned utility lines in their entirety. Furthermore, there was as well a record which provided that QCC's work was only 98% complete, which means that there was a chance that they had potentially missed to remove that pipe, which allegedly fell on plaintiff, which is why James Hunt, Marco Realty, and Gap and Old Navy did not know about the pipe at the time of the accident.
Well, I think James Hunt, as I already said, is still, there's a question of fact as to what their responsibility was. And as to QCC, on the contractual indemnification, it seems that there's still a question as to whether or not they were, this arose out of their work. So those issues seem to be still percolating for the lower court.
Well, I guess what we're trying to say is that, you know, the phrase arising out of has been uniformly and unanimously interpreted by the courts of this state to mean originating from, incident to, or having connection with, regardless of whether the phrase employed in contract for indemnity or insurance per Riviera versus Columbia Hicks Associations in the First Department. Time and time again, this phrase has been interpreted as exceedingly broad and requiring indemnification, even in the absence of a finding of negligence or fault on the part of the indemnitor. Therefore, what I'm saying is that because this claim is very broad, this paragraph is very broad, that there should be given weight to it.
Thank you.
Thank you very much.
Thank you all. Rubin versus Kalon.
Good afternoon.
Afternoon.
Your Honor, may it please the court, Richard A. Altman for Mr. Rubin. The burden on a plaintiff who wishes to sue for defamation is a relatively light one. When
Well, let me
even if
ask
the
you this.
defendant,
If it's
even if the
okay, I'll
plaintiff-
ask you a question if you don't mind.
I certainly don't.
So to state a defamation claim, and that's what this is a defamation case, and to state a defamation claim, one has to allege that the offending action, here this Facebook post, was of and concerning the alleged aggrieved person. Obviously for you, that's
Correct.
Mr. Rubin. But I'm curious as to how you show that this post on its face is of and concerning Mr. Rubin, where there's no mention of a name. The buildings are not identified, although it does refer to 3 buildings, or not even 3, buildings on the corner of 68th and 2nd. There's no doorman mentioned at all, and there are many, many doormen in those 3 buildings. There's no specific details, except that this person was friendly. I imagine that's an MO of the majority of doormen, but that's a subjective description. So what is it that makes this post satisfy the requirement of and concerning the individual?
The mistake here that was made, and it's a mistake that I think was made by the respondent, is that there's a conflation of the oral statement with the written statement. And there's case law which makes it clear that in such a case, it's 2 causes of action, okay? What we know is that he's called in on some date. We don't know the date of the posting, and we don't know when the oral statement was made. But we do know...
We do know the date of the posting. We know that it's a potential date, either January 21st or January 22nd. But we know that he was suspended on January 17th, which predates either January 21st or 22nd.
He is called in
And he's
by the
suspended.
management, confronted with a picture of the respondent, says, "Do you know this woman?" And he says, "Of course." She says, "You touched her child."
Was there any reference?
Therefore-
Was there any reference to a Facebook post in that meeting when he was called in?
It is not clear what the connection is between the oral
Well, it
statement.
couldn't be, right, because the
which led his-
Facebook post hadn't been made yet.
Again, I don't know the answer to that
Okay.
question. What I do know,
You know, it's easy to, we don't know if it was the 21st or the 22nd, but it does seem clear that this Facebook post didn't come out before the 21st or 22nd. We do know that he was in the office with the building managers on the 17th, and that he was suspended. Now, you're, I think, speaking to whether or not they told him at that point that the woman said anything? Is that what you're talking about?
they did tell him that the woman had accused him.
Okay.
There's no question about that.
How else would they have known?
How could they have known?
How else would they have known but for...
How else would they have known other than
Exactly,
that she told
exactly.
and
So
that
that's-
she had accused him?
Exactly, that's January 17th, and he's suspended.
And-
Counsel, is there an
Can I just
allegation?
wait, can you just
Oh,
wait
I'm
till
sorry.
he's answered?
Mhm.
What's the,
Again, I don't know the date. There should have been discovery here. There's all kinds of evidence that was supposedly connecting him to this incident. There was a video which sickened people. Everybody in the building knew about it. This is all in the verified complaint, which has to be assumed.
Speaking of the complaint, because that's where I was going, is there an allegation in the complaint that the employer was aware of the Facebook post? Was there an allegation in the
We
complaint?
don't know. I don't know when they were
what do you
aware
mean,
of
there's
the
either an
Facebook post.
allegation
I didn't-
in the
I didn't see
complaint
it.
or there's not.
I beg your pardon, Your Honor.
You say you don't know, but presumably you've read the complaint. There is either an allegation in the complaint or there is not, with regard to what my
There is an
colleague just...
allegation in the complaint that
Is-
he was confronted with the accusations
The
and confronted
Yes.
with the accusations. He doesn't know what the source of those allegations was, but they are certainly accusations of a defamatory nature. And we have to know, and we know that there was a Facebook post, but as I said before, these are connected. There are
Okay, thank you. Counsel, your time is up.
There are
I'll
cases,
let
Your
you finish up on rebuttal.
I can cite you a case of Bishop versus Chirico.
Okay.
A
And you can-
10882nd.
Thank you very much, and you can give
1061.
the others.
Where a defendant,
Counsel, your time is up. I will give you rebuttal. I would like to hear from the other party now.
May it please the court, Joseph Servini for the respondent cross appellant. I will directly respond to what's been ongoing. So I think one of the questions that was going to be asked is there an allegation in the amended complaint that there is an additional defamatory statement other than the Facebook post? And there is not. The only defamatory statement that is alleged is the Facebook post, and that is important, Your Honor.
Wasn't there a conversation with them that led to the suspension?
There's an allegation, Your Honor, of a conversation, and that conversation is, and it occurred on the 17th, that was 5 days before the Facebook post. The conversation, there's no specificity alleged with any defamation claim with that statement, Your Honor. All of the
He wouldn't have been present for said defamatory statement, but something was communicated because the employer showed him a picture and said, "Do you know this person?"
There's no specificity with any defamatory statement. However, the statement that is alleged is, she complained you touched her daughter. Now, what's important there, in paragraph 21 of the complaint, he admits that he touched her daughter on multiple occasions. So that can't be the defamatory statement which is being alleged. What is being alleged is the Facebook post, and that's very important to understand. If I can just focus just on the highlights here, which are 2 points. His whole position with Justice Lattin's decision is he overlooked facts, and there's 2 facts. The first, I think, which has been kind of dealt with, did Rudin have any knowledge of the Facebook post? And I think the answer you received was, we need discovery. He had a conversation with them. He spoke to them, and they never mentioned it. That's his own admission. And to be fair here, all of the allegations come from the amended complaint. There's no other document in the record. So we're talking about the amended complaint. And what's been going on in the lower court and here is an attempt to rewrite the amended complaint, because there is no nexus alleged between either Rudin and the Facebook post. They don't know about it, according to there's no allegation that they were aware. More importantly, there's no nexus between the Facebook post and his termination. And quite frankly, I think you pointed out, he was suspended 5 days before the Facebook
17th.
post. And what's also important, the termination letter, which is Exhibit B to the amended complaint, makes no mention of the Facebook post and instead gives an independent basis for termination, which was based on a thorough assessment of his conduct. And what's also important, and I think Justice Latin pointed out, and he cited this court's decision in Ruiz versus, excuse me if I get it wrong, Lapper-Skook, and he cited that for the proposition of what's required for of and concerning. And the allegation in the papers now is, well, other people knew it was him in the building. There is no allegation in these papers that anybody, including people in the building, were aware or believed this was him. In fact, the only allegation that exists is an allegation that the Facebook post was widely known in the building. There's not a single allegation that anybody believed it was him. And quickly, I will deal with the fact that Justice Latin's decision is correct. And there is a cross appeal for fees under the anti-SLAPP statute. I will just say our client's primary concern is she's done nothing wrong here. Any claim that actually exists is really against his employer, Rudin. Our client did nothing wrong, the respondent. And quite frankly, the decision is correct. And although it is on a public forum, which is Facebook, and it is a matter of public concern, there isn't a substantial basis because it's dismissed under 3211A7. So our client is entitled to fees and costs, but just wants this nightmare over. She's been sued incorrectly. She wants to move on, and it's totally unfair. All she did was try to do something and put out a warning, didn't name him, didn't give any identifying features, and now she's being sued for thousands of dollars in legal fees and damages. It's just not fair. Thank you, Your Honors.
My client was fired from his job, has been forced to go Medicaid, take Medicaid, has been unemployable, and has taken early security.
Counsel, I understand. I understand all of that. I'd like you to stick to the case law.
I shall.
Because that is not
I shall.
relevant consideration here. It's about what was stated either on the 17th, but from what I see, it's the Facebook post on the 21st or the 22nd that you are raising as the defamation.
The standard of and concerning is a rather low bar. If you look at the Three Amigos cases, the Three Amigos case where a corporation was accused of mafia connections and employees of the corporation said it was of and concerning them. Yes, they lost, but 3 judges, including 2 from this court and 1 from in Albany, said they should go forward with the case. The standard is very low. The respondent is concerned about this lawsuit. Why didn't she put in an affidavit at any point saying, I did not mean to talk about Hal Rubin. I was talking about somebody else. No, we have her lawyers making the absurd, frankly, absurd argument that maybe it was another doorman in another building. What, did she bring her daughter around to another doorman in another building?
I just sticking to the Facebook post, because I just went through the amended complaint again, just to make sure that we're on the same page. And I don't see anything identifying building name. The amount of doormen in the area saying that maybe this one doorman on this particular street, it was an anonymous post, and it was 3 days or 5 days after the first contact with the people in the building. So, and it references specifically the post. It doesn't talk about any other conversation. So, in this particular document, maybe you can point me.
Because it is your burden, counsel. It is your burden to prove.
I understand.
Okay, good.
The Facebook post said, "Oh my God, I thought this man is grooming my daughter."
What does that have to do with identifying which out of however many doormen this person is?
I go back to what I said. Why didn't the defendant put in an affidavit saying, "I didn't mean Mr. Rubin"?
Can I?
Everybody assumed that he was the one named. Everyone assumed that he was the party.
Who is
you
everyone
address-
that you, I'm sorry.
His man.
I just want to, you haven't addressed the cross motion, the cross appeal. You haven't addressed that. Do you want to address why your client shouldn't be responsible for the fees?
Because
That's
he
your
was,
position?
unless you want to say that any false accusation of child molestation is a matter of public importance, then the answer is no. They're not entitled to legal fees. They're not entitled to anything.
Counsel, I'm sorry to cut you off,
Yes.
but I have to get back. You're making that statement, that's sort of a global, expansive statement when it's your burden to demonstrate that the defamatory statement referred to your client. We have been asking you this entire time to give us an explanation of how that statement, anything in that statement specifically is of and concerning your client. I
If
haven't
the-
heard you say anything yet.
If the Facebook post, there are two defamatory statements. There's the oral statement, which was reported to him by the
That's
management.
not inside the amended complaint. It only talks about Facebook repeatedly.
The Facebook post is a repetition of the oral statements in the first complaint, and they have to be read together, and they should be read together. If there's any question here, all the court should have done is allow some testimony as to who exactly was meant. It was a very simple matter. There was enough here. People thought that Rubin was the man accused.
I don't know who the
Facebook
people are
post
because
was-
that's not here. I don't know who the people are who you're talking about. That's not part of the record.
The question is whether people who knew the plaintiff assumed that he was the person. And the people here, his employers, the
Well, his
management-
employers had to know something about him because they are the ones who suspended him.
So based on what did they accuse him of showing him the
I'll ask the
defendant's
questions, and you haven't met your burden yet. Thank you very much. Thank you both. Fernandez versus Sub 412.
Good afternoon, Your Honors. May it please the court, my name is Christine Emery from P&K Park LLP, representing appellants Sub 412, 2398 Realty, Aramis, and the Estee Lauder Companies, Inc. We're here asking that the court reverse the summary judgment orders dated April 25th, 2024, and
Why don't we
August.
start with the 241, because you have a claim for that also, right?
The 240
sub
sub
1.
1. 240 sub 1, yes.
Right. So the single decisive question, as was said in Quattrochi, is whether the plaintiff's injuries were the direct consequence of a failure to provide adequate protection against a risk arising from a physically significant elevation differential. How is this slab that fell on this plaintiff not a physically significant elevation differential?
Well, first of all, Judge, at the time that the incident occurred, the work was already completed.
Well, it wasn't completed because there hadn't been any inspection of this slab that instead of having the pin in the cement, it was in the not plasterboard, but whatever that product is. Sheetrock, thank you. It was in the sheetrock. So that hadn't been inspected yet. So it's not a completed thing.
That's correct. Our position is a little bit different. Just because the final sign-off inspection hadn't occurred doesn't mean the work wasn't done.
Well, how is it different from, I think, the Delsid case, where the worker was injured when a piece of wonderboard that had been screwed into the lobby wall the day before the accident fell on him?
So in Delsid, it was a little bit difficult from the decision to tell what the scope, the undertaking of the plaintiff's work was with regard to the wonderboard, at least how we read it. Here, the undertaking
I
of the work.
read it as a piece of wonderboard is screwed into a wall. That pretty much means that it's there to stay. And it doesn't stay, and it's the day before. And here, we have a ceiling, a hanging ceiling, that is screwed in improperly. The company admits it, and it falls. I don't understand how that's different there.
Well, it was not in the process of being hoisted or secure.
Doesn't have to be. That's not what the case law says. What it says is that consequence of a failure to provide adequate protection. In other words, either it should be there and be able to stay, or if it's something that hasn't been finalized yet, it should have some, I don't know, netting, hanging, whatever it is. I don't come up with the safety devices, but there should have been one.
With the exception of the final sign-off admittedly not occurring, I think all parties were under the impression, including the plaintiff himself, that the work was done and complete. Nothing was ongoing at the time. Our position is that the incident that occurred here was a result of an ordinary hazard of the construction work, as opposed to one with regard to that the extraordinary protections of labor laws 240 sub 1 should apply. This is not well, I already said that. Plaintiff presented no evidence that a protective device such as scaffolding, hoist, ladder.
Plaintiff have to show what safety device was appropriate or was necessary, or is it the fact that the ceiling fell on him enough to show that there wasn't an adequate safety device provided?
Well, I think that plaintiff might not necessarily need to show what specific safety device was required, but that he was being exposed to an elevation type risk to which.
When something falls on you, there's no height differential involved there?
Well, I mean,
When a ceiling falls on someone, the ceiling being up falls on someone being on the ground.
If it had happened, if it had been improperly installed and this incident would have happened, with a bystander or 6 months afterwards, I don't think we would be here today.
I mean, does that dispute the fact that the screws and the nails that were supposed to hold this ceiling in place, put in a certain position so that they would stay in place, weren't there? They were in a different position, which caused the ceiling to fall. The screws maybe being the safety device that weren't adequate. I don't know, but something happened.
I think that's what plaintiff's position here was, that the pencil rods that were used to affix the floating ceilings were safety devices where they were not here. These were not safety devices to protect construction workers. They were intended to affix and become part of the permanent structure.
Thank you. You have some rebuttal.
Understood.
Good afternoon, Your Honors. May it please the Court. My name is Christine Taylor from Brody Law Group on behalf of the appellant, respondent, and Field Interiors, Inc. Our motion is seeking really reversal of the decision that granted plaintiff summary judgment on his Labor Law 240 claim. We believe that there are questions of fact that should have prevented that decision. And I'll just point out the two cases that Your Honor mentioned.
Anfield was the subcontractor that installed the ceiling?
That's correct, yes. The two cases that Your Honor mentioned, Croce and Delsid, both found that there were questions of fact on 240. They didn't grant plaintiff 240. So I'd just like to point that out since Your Honor brought those up. And I'd also like to focus on the fact that there is a case law from the Court of Appeals that safety devices, there has to be a safety device of the type enumerated in the statute. Those safety devices, mean those devices used to support an elevated work site, not those devices used to lend or shore up support for a completed structure, which is what we have here. So in the case of Miseriti, this is the case where a plaintiff constructs a firewall. He's sweeping on the ground by the firewall, and then the wall collapses on him because it hadn't been vertically braced. The Court of Appeals said, even though braces are specifically enumerated in the statute, those are not the type of braces the statute means. What it means is those devices, again, meaning to lend support to an elevated work site, not those devices to shore up a completed structure, which is what that was. So,
no, I'm just going to say that this structure that this person was working underneath had not yet been inspected. It seems like that's irrelevant here, that it couldn't have been finished. People were working above and around it, and it hadn't been inspected. It was an active work site, and it fell, and there was nothing, no support at all to prevent that. I'm not clear on why there would be a question of fact there.
Sure. So it's our position that the floating ceiling was completely installed. It had been completely installed according to the record. No one knows exactly when it was installed, but it had been installed at some point in time prior to the accident date. That's supported by plaintiff's own testimony. He said it had been
Well, it was up there.
Sure, yeah, it was up there. It had not been inspected, I admit that, but the installation had been done. And there's no evidence in, for example, Miseriti that the wall...
Is it the position that you're taking that if the ceiling had fell contemporaneously with someone installing it and him walking underneath it, that's the only, simultaneously rather, that's the only way that 240 could apply?
Well, it's our...
Because once it's been up there, now it's quote unquote maybe permanent?
Yeah, I believe that's the holding of the Court of Appeals. And that was also the case in Fabrizi, which was where there was a conduit that was holding in a pencil box, and the pencil box had to be relocated. So this had been put in about a week before the accident as part of the work.
Didn't plaintiff testify that work was being done on it just days before and that there was no final sign-off on this? What about that?
Plaintiff didn't testify about the sign-off. He didn't know about that.
Yeah, but that work had been done just days before.
He testified that he didn't know. He didn't give a time frame. He said he testified, the first time he testified was at his first deposition. 3 times he testified that the work had been done prior to the accident date. He couldn't approximate a time frame. No one in this case could approximate a time frame, but everyone who testified said that it had been done before the accident date. So the owner of Anfield testified that it was done before the accident date. The owner of Nucor testified that he didn't know when it was done, but that the sheetrock would have been the last piece of the installation, and that had been done before the accident happened, and as well as the testimony of the Design Republic representative who testified that she observed after the accident that there were electrical wires in the ceiling, which would have been installed after the installation of the ceiling, floating ceiling. Thank you.
May it please the court. My name is Nick Bavanti, representing Nucor. In addition to what they said about 240, I also want to talk about 200. I believe my client should be, claims against him against them should be dismissed. Nucor did not actually supervise or control the work. Authority is insufficient.
That would have been Anfield.
That would have been Anfield, correct, Your Honor. And case law is clear on that. They were not responsible for the work, and Anfield themselves installed the
They were not responsible for the means or method. They had no supervision or control over that aspect of it.
Unless the court has any other questions on that topic, it seems like you understand that issue. Going back to 240, I do want to point out the case of Buckley versus Columbia Grammar. That was a case where an elevator counterweight fell while construction was still ongoing. The court said that 240 did not apply because that was permanently installed structure, even though construction on the elevator itself was still ongoing.
Thank you.
And also, if there's any other questions, I'm happy to, thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. John Shore for plaintiff respondent. First of all,
What would you like to say about 240 sub 1?
Absolutely, Your Honor. First of all, there's nothing better than their Nucor's own expert who they retained. Plaintiff didn't retain him. Robert O'Connor, in his affidavit, unequivocally averred, and that's their own expert, paragraph 19, page 1617 of the record. At the time of the incident, the installation of the suspended ceiling was not completed, so no formal inspection of the suspended ceiling had been held for the final sign-off of Anfield's work. Clearly, the work was not completed.
Is the only way to show that work is completed is through a final sign-off?
Actually, not. And secondly, with respect to the Delcid case, I actually was before Justice Kennedy not that long ago on the Delcid case. And this court, as Justice Renwick also noted, said it doesn't have to be worked on contemporaneously. In the Delcid case, the Wonder Board was completed the day before, but construction generally was ongoing, and there was a screw that was not properly installed. And counsel misstates the record about Delcid. First of all, plaintiff did not move for summary judgment, and there was a request for this court to search the record, which was denied. But there was a question of fact in the, as noted in the decision, not with respect to whether or not there was a violation of 240 and it is not a permanent structure. The issue of fact was whether or not plaintiff was working in the lobby at the time of the accident, and so there was a question of credibility. So that is a complete misapplication of the case. There's no—
I'd like to move on to the 200 claim. What evidence did the plaintiff present to demonstrate that Nucor, exercise actual control over Anfield's work?
Sure, through the words of the contract, Your Honor, the words of Mr. Palacci, and the words of Mr. Duffy. In the contract itself, 9.2 of the contract, which was not, which is a deficiency in Mr. O'Connor's affidavit, by the way, he specifically wanted to show in his affidavit that Anfield, through the purchase order, was responsible for controlling the work of the ceiling, but conspicuous by its absence shows they didn't even sustain their burden. He was not provided this contract, this AIA contract, which Section 9.2 specifically says that Nucor was responsible for controlling the means and the methods of this work. He was not even provided that. Secondly, Mr. Palacci testified that not only did Mr. Bono, he was there on a regular basis, and he was there on the day of the accident, but Mr. Bono, along with the project manager as well, were responsible for checking the work to make sure that the ongoing work was being properly done in accordance with the plans and specifications.
Right, general supervisory authority, but
Well,
certainly, there's case law that says that, you need more. That's not enough. So what else besides that?
I understand that, but between the contract, which gave them the authority to control the means and methods of the work, Your Honor, And they did not sustain their burden because Mr.
They had to
O'Connor.
have specific involvement in the means and methods of the work to be involved in that way.
Well-
I mean, Anfield, they were the contractors. They put that whole thing together. There's no way that Nucor, in just doing the usual inspection, walking around, making sure that the place is safe, is going to know that there's a nail up there or whatever that's not in cement, but it's in plasterboard.
In this case, Your Honor, it wasn't that they were not at the scene and didn't have the responsibility. In this case, Mr. Bono, along with the project manager, was responsible for checking that work, and Mr.
You're not talking about inspection.
It encompassed an inspection.
What would
it did not say that he had to specifically go up there, but he was responsible for checking the work as it was ongoing, and we're talking about.
But how would you know, unless you did an inspection, how would you know that somebody had put the nail into the plasterboard instead of the cement?
Because it goes beyond general supervision, Your Honor. In this case, in addition to the contract, where not only were they responsible for controlling the means and methods of the work, which they did not refute through Mr. O'Connor, they said, Mr. Palaci said that not only was Mr. Bono right there when they were doing the installation of the work, but Mr. Bono and Nucor were responsible for checking the work and monitoring it and making sure that it followed the plans and specs, which they said, obviously, when they looked at it, they said, this was totally wrong. The pencil rod was 50% was hooked to the
Thank you very
slab
much.
as opposed to the
Still talking.
wooden. Thank you.
Thank you.
Your Honors, while I still have a couple minutes, one issue that is raised in our.
Go back to the Delcid case. It was the defendant's motion, which is why questions of fact were found, and this court didn't didn't search the record to grant. So we don't know what would have happened in that instance. But what we do know is that we found that that the defendant's argument that the statute did not cover the Wonder Board because it was a permanent fixture is unavailable. Does that change your position somehow? Or should it? Because I know you're not going to concede to it.
Yeah, I don't think it does. But to the extent
And
that
in that case, the pre-existing fixtures were there before the work even began. We don't have that here, right? It's a little bit different.
That's true, but to the extent that there were issues of fact found there, we agree that there are issues of fact here. Very quickly, I just wanted to mention at the summary judgment stage, co-defendant Nucor had sought an order granting contractual and common law indemnification against Anfield. Judge Moyne's decision granted Nucor conditional indemnification against Aramis. The decision doesn't offer any rationale for that. We don't believe there is any grounds for conditional indemnification against Aramis, and we ask that this court remove Aramis from the decision. Thank you.
Just briefly, I would like to address the issue of the installation, the cause of the fall of the floating ceiling. It has not been established that the cause was the installation. As a matter of fact, it is, there is a decision issued by the lower court already. It's the law of the case that whether the design of the floating ceiling was negligently done is a question of fact. So the cause of the collapse is going to have to be determined by the jury. It's not necessary.
Designs, though, did they call for the fixing devices to be put into the sheetrock?
They didn't. The designs didn't specify what types of devices to use to
Did it specify where?
It's,
where the devices should be put in? Did it say put them in the sheetrock?
It did not, I don't believe it said that, and I don't believe it was installed in the sheetrock. I don't think that's a matter of fact. My client testified that the devices were installed in the slab and they were installed in the soffit, which he described as a metal beam that was covered by sheetrock. But the device, the pencil rods themselves were actually installed into the beam, according to my client's
Where did the
testimony.
design say to put them?
I don't know the answer to that, to be
You are
honest.
making this argument for 240 sub 1?
No, I'm sorry. I'm just pointing out that this has not been established
Okay.
because it goes to Nucor's
Yeah, I see.
cross.
It-
Yes.
Lack of
So
response.
they didn't address the issue of the potential negligence on behalf of Design Republic. They were responsible for coordinating with Design Republic if there were issues with the plans to go back to Design Republic and say, what is, we need a correction on this, we need clarification. They were responsible also for ensuring, according to my client and according to their own witness, ensuring that the installation of the floating ceiling was done in accordance with the plans. They didn't do that, and they were contractually obligated to supervise and control the work. And so for that reason, we believe that they should properly be denied full contractual indemnity.
Thank you.
The plans specified that the pencil rods were supposed to be put into the concrete structure. The soffit where the pencil rods were installed into was not part of the plans. Anfield's installation of the ceiling did not follow the plans, which is why is our position that why it fell. Palazzi testified that he saw the pencil rods in the soffit after the accident occurred. And questions on 240 or 200? Happy to answer them.
Thank you.
Thank you.
That's it.
Thank you all. People versus Gregory Darby.
Good afternoon, Your Honors. May it please the Court. Nkechi Irandu, Center for Appellate Litigation for Gregory Darby. The officers here had no basis to conduct a warrantless search of Mr. Darby's backpack because there were no exigent circumstances. Therefore, the gun recovered must
What
be
do we do
suppressed.
about the waiver? Let's say we agree, my goodness, this was a terrible search. Not saying we do, but what if? What do we do about the fact that there's a waiver then? He pleads guilty.
Of course, the waiver is invalid here. The law is clear. When a court tells a defendant that the right to appeal is lost by pleading guilty, that misstatement alone is enough to invalidate the waiver, and that's exactly what we have here. The court told Mr. Darby that by pleading guilty, he was giving up his appellate rights. Yes, he used the magic words of separate and apart, but if he uses the word separate and apart and then immediately follows that up by saying that his appellate rights are extinguished, then that appeal waiver is invalid. Furthermore, the court said that Mr. Darby would give up his right to challenge any mistakes or any errors, which of course is an overbroad statement. There are of course issues that remain and are non-waivable and survivable even with an appeal waiver. So I would now like to turn to the merits. There were no exigent circumstances here. Mr. Darby was completely cooperative. He was smoking a blunt, and four officers approached him and asked him for his identification. He took 2-3 minutes to search his person for his ID, and then that does not sound like a fast-moving situation. That is not an emergency. The cops stood by.
Exigent circumstances created when the backpack was placed on the ground and there was a clanking noise?
Sure, but the Court of Appeals has made clear that a clanking noise, something as innocuous as a clank or heaviness, cannot establish exigency. The officer even admitted during the suppression hearing that the clanking noise could have been anything. It could have been a water bottle. It could have been the metal scale that was actually in Mr. Darby's backpack. So what we have here.
So a clanking noise has been found not to be a basis to open up a bag?
Yes, Your Honor. A clanking noise alone is not a basis to conduct a warrantless search. I have a water bottle, a metal water bottle in my purse. I assure you that if I drop it on the ground, it will make a clanking noise.
But it's not, I think the officer said more than that. It wasn't just an ordinary clanking noise. It was something that he, based on his experience and handling guns, said he felt because of the weight and because of the type of noise that it made, that it was possible that it was a firearm.
Yeah, but possibility does not necessarily allow an officer to conduct a warrantless search of that backpack. If the officer was truly concerned for his safety, there were a lot of other protective measures that the officer could have taken that wouldn't.
Right. He could have taken that bag and given it to another officer. Another officer could have put it in the trunk and secured it. But the question is whether or not under these circumstances where things, I know you say 2 to 3 minutes, not unfolding fast, but they've given this person the opportunity now to find the ID. It is now 3 minutes, and now they're getting a little bit concerned, and they take the bag, and it makes this noise, and now they're thinking there could be a gun in there. So under those circumstances, would this not be
No,
appropriate?
it wouldn't. I think it's telling that Mr. Darby never actually reached into his backpack. He never, while he was searching for his ID, he wasn't ever searching within the backpack. So that actually shows that he wasn't ever going to go for the backpack.
Is he now on post-release supervision right now?
Yes, he is. Yes. So again, none of the factors here establish that there was an emergency. The level of intrusion that an officer takes has to match the safety concern. And that just didn't happen here. The officers had full control of the situation. They had plenty of options that wouldn't rise to the very high level of intrusion that is a warrantless search of a backpack.
Okay. Once the officer puts the backpack down, and again, given the officer's testimony with regards to the weight and to the noise and how he associated that with a firearm, at that point, I understand that you're saying maybe he didn't have to put the bag down, right? But there was a credibility determination made by the lower court that the officer had no nefarious motive by putting the backpack down. At that point, doesn't the officer have enough?
No, the officer doesn't.
Why?
This case is very similar to Jimenez. The heaviness of a backpack and a clanking noise, it can't be based on speculation or theory that, or a theoretical concern that there is a gun. There has to be, we have to look at all the factors, and nothing in this.
Well, you just mentioned previously that the defendant did not go towards the bag, right? But I think that part of what the officer was saying, that the reason that he didn't go towards the bag in looking for the ID, despite the fact that he couldn't find it on his person, is concerned that there was this weapon in the. So that fact, I think, cuts both ways.
Sure, but
doesn't that help? Isn't that another factor to add into with regards to the heaviness and the clanking noise and the officer's experience based on him carrying a gun daily?
No, it doesn't, because the situation here is we've got Mr. Darby, who again is being confronted because of this low-level, nonviolent offense that, and if we actually uphold this search, then virtually every street encounter where someone has a bag on them and there's a clank, that could turn into or rise to the level of a warrantless search. And the law is very clear that that cannot be the case. And I'll address any other questions on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the court. Stacey Nadell for the people.
Counsel, to the extent that there was an exigency here, wasn't it created by the officer putting the bag down?
This was an escalating encounter. It was the exigency.
I don't understand what you mean escalating encounter. The defendant was stopped for smoking a blunt, right?
Right.
He was asked for identification, couldn't produce it. I don't see the danger so far. The officers have the bag, right? So there's no danger that the defendant's gonna go into the bag. The officers had many options. The officers instead exercised to place the bag near the defendant, causing this clanking sound while there's a scale in the bag. Why is that not all innocuous and it points towards innocence as much as you want to say it points to probable cause or reasonable suspicion?
I would disagree with you, Your Honor, where on the fact that that one, that the officer created the exigency, but two, that all of this was innocuous. This is a totality of the circumstances. So while the encounter started with just a common law right of inquiry, which was the defendant was, at the time, smoking marijuana on a public sidewalk was illegal, this was a proper common law right of inquiry. As the defendant is trying to search for ID, can't produce it, as the panel noted, the defendant did not look in his backpack, which was concerning because if he couldn't find it anywhere else on his body, the backpack would theoretically be the next best place to look. The defendant didn't, so now the safety concerns are beginning to rise, which is what I meant previously when I said this was an escalating encounter. So now we're thinking...
When the officer took the backpack, and I mean, what we're talking about, grabbable area, right? That's where the safety concern comes into play. What's within the defendant's grabbable area? Within those 2 to 3 minutes that he's searching, he doesn't go for what would have then have been in his grabbable area. The officer then takes the, as my colleague pointed out, takes it and places it on the ground, I guess still within his grabbable area when he could have placed it elsewhere. So thereby creating the exigency, because it didn't exist before.
That may be true. There, you know, this encounter could have, 100 different things could have gone differently, but this is what happened. At the time, the officer removed the bag from the defendant and put it on the ground. At that point, there was, in the motion was, the testimony said it was within a couple of seconds. The officer likely wasn't, and the hearing court found this, that the officer didn't do that with the intention of keeping it within the defendant's grabbable area.
Do you agree that if the intention was to keep it within the grabbable area, that there would be a problem?
Again, this is a totality of the circumstances, so we would have to assess that with considering all circumstances. Here, the bag, immediately the officer found the bag, felt it was heavy, put it on the ground, clanking noise within a couple of seconds. Okay, now it was not unreasonable for the officer who has training and experience, has testified to have been involved in several firearms arrests, and carries a gun.
There's also a metal scale in there, right?
Yes, there was a metal scale in there.
There goes the clanking noise. There goes the weight.
Maybe, but it was still not unreasonable for the officer to believe that there was a gun.
Because he wouldn't have known it was a scale until he opened the bag. It could have been anything.
Could have been anything, but given the fact that he felt the heavy weight and then heard this clanking noise,
Scales, are they light or are they heavy? Don't answer.
I'm not. At that time, he's already he's already becoming suspicious about it. But again,
correct.
You know, this creates an interesting situation, I will say. We have to deal with the facts we have, but where an officer puts something in an area where there are other officers, not just two of them here, very easy to hand the bag away from the circumstances so as not to create any further tension or concern, and the bag is put in the trunk or in the car or someplace else. Instead, the bag is put down on the floor, on the ground. You know, it does raise questions, as my colleague asked, and that the court raised, about whether or not these things can be done on purpose to create circumstances. One doesn't know. I don't know how we could know, but...
Yeah, certainly, Your Honor. But in this case, the court actually noted both of those things, the fact that, you know, maybe there should have been more separation between the defendant and his backpack. There wasn't, but the totality of the circumstances in the record indicated that it was not intentionally placed.
We'll never know that.
Well, that's correct. So we just have to work with the facts we have and assess the totality of the circumstances.
So was there any testimony in the record elicited from the officer or anyone else as to whether the officers were planning to arrest him or something else at the time that they asked him for identification?
There's nothing in the record to suggest that they were definitely planning to arrest him. However, because he was smoking marijuana, admitted that it was a blunt on a public sidewalk at a time where it was illegal to do so. They could have, correct.
But there's no indication that that was their plan at the time that they approached him.
At the time that they approached him, there's really nothing in the record to say either way. And with respect to the waiver, this waiver was valid. Again, this is also a totality of the circumstances. situation which, with the oral colloquy, the written waivers, 2 of them, and the defendant's repeated confirmations of his understanding is represented by counsel, who noted that he was confident his client understood the rights and consequences of the waiver. The waiver was valid and therefore precludes this court's review of the search as well as the excessive sentence. Thank you.
As Your Honor suggests, the police cannot manufacture exigency. They can't partially secure a bag and then speculate about Mr. Darby gaining access to it. The fact that they took the bag away from him and left the bag in the grabbable area suggests that obviously the concern around safety couldn't have been that high. The totality here doesn't save the search. Respondent talks about nervousness, which is reasonable for someone who's being confronted by 4 police officers. The fact that he couldn't obtain his ID, smoking marijuana, the high crime area, the clanking sound. Again, all of these innocuous facts do not rise to the level of an emergency.
What about the fact just that the court made a credibility determination and heard all of the testimony here and made a determination that it was a proper search?
Absolutely, the court made a credibility determination, but this court has the jurisdiction to look at the facts here and assess whether there were facts that rose to the level of an emergency, and there were not. And if there were no further questions, I will rest on my brief.
Thank you very much. Thank you both. People versus William Bunce.
Good afternoon from Mr. William Bunce, Office of Appellate Defender by Christiana Prater-Lee. A modest 6-month reduction here is appropriate where Mr. Bunce was firing back defensively in response to shots fired at him and no one was hit. As the prosecution acknowledged at the plea, Mr. Bunce did not have his gun out when he was fired upon. He was crossing a street on his phone when shots bounced off the vehicle next to him and he was forced to duck. This court has been provided the video of the incident. I invite this court to look at it and see that Mr. Bunce did not pull out a gun until he was fired at repeatedly.
The video, I saw the video. It's not clear to me what evidence is there that he was being fired at, as opposed to him being around someone firing a gun.
The shots were mere feet away from him. He was crossing the intersection.
There's no doubt that after that, he basically unloaded. He fired many shots.
He first ducked behind a vehicle, and then at that point, he took out his...
Went into the middle of the street, started firing.
Yes, he went back in the street. We don't know where the first initial aggressor was at that point.
Okay.
We don't have any other information about where these shots were coming from. We know 6 to 7 shots were fired at him while he returned 3 shots before he ran away. And in these circumstances where this court has the video, it's in a much better position than the lower court, which did not have the video and said it had a hard time fashioning an appropriate sentence for Mr. Bunce. And for a young man here, he was barely 24 years old when this incident
Why didn't the lower court have the video?
The lower court did not have the video before it. It was asking the prosecution for the information about the video. It may have viewed the video at some point, but at that point, it was not viewing the video when it was asked to make its plea determination. And so here, where Mr. Bunce...
Was the video part of the record in the lower court?
Yes, it was part of the record.
Just the judge didn't see it?
The judge did not acknowledge that he saw the video. He was relying on the prosecution's representations of the video. And here, where Mr. Bunce has served nearly 4 years of incarceration, another 6 months to the 4.5 to the 5-year mark is simply, there's no rehabilitative effect at this point. Mr. Bunce's family is waiting for him. His young daughter, who is now in elementary school, is waiting for him.
Thank you.
Good afternoon, Mary Bijumenian for the people.
Defendant was convicted of criminal possession of a weapon in the second degree, a crime that was committed the moment he stepped onto a public street with a gun. Defendant's sentence is the exact sentence that defense counsel asked for below and should not be disturbed on appeal. All of the purported mitigating factors that defendant raises again on appeal were carefully considered by both the plea and sentencing courts below. And if your honors have no further questions, the people ask that you affirm.
Thank you.
We're not discounting the severity of his decision to carry a gun, but here 4.5 years is still appropriate sentence, still lengthy sentence for a man who's serving his first significant term of incarceration, his first term of incarceration upstate. So for these reasons, we'd ask this court to reduce his sentence of incarceration by 6 months and his term of post-release supervision from the maximum of 5 years to something closer to the minimum of 2.5 years, as this court has done repeatedly, as this court did this week in Tiara Richards' case. A slower term of post-release supervision is appropriate for a young man who is returning home to his family and does not want to have the barriers, does not need to have the barriers in place to restart his life after serving a significant term of incarceration for the first time.
Thank you. Thank you both. Day versus Plumber's Shop.
Good afternoon, Your Honors. May it please the court. My name is Jeremy Berman with Rousseau and Gould. We represent defendant appellant Plumber's Shop.
Counsel, I noticed that correct me if I'm wrong, your argument is that the language is not ambiguous. It should be taken at face value. But I don't see, I understand that the lower court found that it was ambiguous and then it used externally, but I don't even see how on face value it helps you. Property damage is all over the document. It doesn't say anything else.
No, it does say, Your Honor, it does say something else. It says property damage claims which the undersigned now have or may have to accrue, or in any way growing out of any and all known and unknown foreseen property damage. So what is in any way growing out of?
I don't know. That's the problem here. It says growing out of property damage. It's just property damage is property damage or a property claim, and it's not defined anywhere.
Well, I think we have to just look at the words growing out of. Growing out of has been interpreted by the courts, just like arising out of, to mean any connection. So is there a connection between ALE and property damage? The answer is undoubtedly yes. Why is the answer undoubtedly yes? Because in order for there to be ALE, there has to be property damage. If somebody's house, apartment is ruined, then there is ALE because the person has to move from the apartment. So there is a direct causal connection between the property damage and the ALE. So when it says growing out of property damage, that must mean ALE. What else does it mean, though? I mean, it's...
That's what it means, but why just not say it?
What else does it mean? That's what you should have to be clear here.
Because it doesn't have to say it, Your Honor.
When it doesn't say it, then we're here.
But it does say it. It says growing out of. I mean, the courts have construed growing out of to mean in any way connected. As I just said, I apologize for repeating myself, but growing out of means ALE grows out of. And they've admitted this. When they filed their complaint, their amended complaint, this is what their amended complaint says. And it's in the record. Sorry. Paragraph 8 of the amended complaint says that, and it's in the record at page 54, record 54, as a direct result of Plumber's negligence, plaintiffs sustain significant property damage and consequential losses, including but not limited to plaintiff's loss of use of her home. So they're saying it's a consequential damage. What does consequential damage mean? consequential damage means grows out of.
Counsel, what weight should we give to the May 23rd, 22nd email found on page 73 of the record? And I'll just read it because it's very brief, from Chris Watts. Good afternoon. This message is being sent to cement the details of our earlier conversation regarding your client, Linda Day. Guard has offered $300,822.98 in full settlement of your client's property damage claim. Please advise when this offer is formally accepted. Of note, we will address the ALE portion of claim as the proofs are provided by your office. So can you
Yes,
address
thank you for
this?
asking that question. The answer to that is this was an email that was written 4 months before the signed agreement. In that 4-month period, you had a new agreement that was entered into. The new agreement, originally, what this was talking about was a deal at $308,000. The ultimate deal that was signed was $338,000, $30,000 difference. It doesn't say you can.
But the input of the email is that it's treating the ALE, is that?
ALE, correct.
ALE differently than property damage.
But what he's saying is you can supply, it doesn't say in that email, again, 4 months earlier, and I want to go into one more point about that email. Well, it doesn't say that you can submit claims for ALE after release is signed. They're still in a phase of negotiation, and they're talking about it. And Your Honor, there's a parole evidence rule. The agreement says this constitutes the entire agreement between the parties. That means what it says.
But it says property damage release, right? It doesn't say
Yes,
general
Your Honor,
release.
it does say that. But there's case law, we cited in our brief, it says that the title is not determinative of what the release encompasses. It's the body of the release. The body is explanatory of what property damage release means. And there's nothing inconsistent with saying property damage release and then saying property damage release and all damages growing out of the property damage release.
Thank you.
Thank you.
It's been a long afternoon, judges. I'll be brief. The court is right.
What about that connection that opposing counsel makes that it's growing out of, right? It's all one thing.
Well, it says property damage, including unforeseen property damage, that grew out of the flood damage, the property damage that occurred on October 30, the date of the flood.
So it's just referring to property damage.
It's all over the place. And I think, Justice Lebovitz, we argued below that it was clear and unequivocal, that it was a limited release. Our jurisprudence falls along two lines. It's either clear, I release all claims of whatever nature, then we're not here. Or it's limited by some language. Here it's very limited. I think Judge Lebovitz had some difficulty with the scope of what property damage might include. He found it ambiguous. Chris Watts of Guard, the plumber shop's insurer, drafted this document. And his writing is crystal clear. I'm in this from the very beginning. I drafted the complaint. Linda Day is my client from the very beginning. With all due respect to counsel, he's 2 counsel removed from those negotiations. And I think Lebovitz saw the Watts email and said, from the very beginning, the complaint said, we've got damage to property and we've got other costs that grow out of the negligence of the plumbers who did the work 2 floors above us, which caused a massive flood that went on for 8 hours.
We know the facts, so we understand the alternative living expenses versus the language property damage claim.
Yeah. We think Judge Lebovitz got to the right place, his own path. You could either find that it's clear and unambiguous and it's limited, or you could agree that it's ambiguous, but the only extrinsic evidence
Either
placed
way,
before the
it's
court
not good
was
for
ours.
your adversary, right? Because it's either clear, it's plain on its face, or it's not, or it's ambiguous, and
And if it's ambiguous, the only extrinsic evidence offered was
That
us.
email.
Didn't answer it, nothing from Watts, they had the opportunity. And beyond Watts, there are statements from Jared Cherney at record at 77 through 79, where he's talking with me about getting a check drawn. He refers to it as a property damage release. There is no one who refers to it as a general, broad form, all claims release. So we ask that this court affirm Judge Lebovitz's decision.
Thank you.
Your Honors, there's an important rule of New York contract construction. And the important rule of New York contract construction is that all words in a contract should be given meaning. And no words and terms should not be rendered meaningless by an interpretation of a contract. Frankly, I did not hear any explanation of what claims growing out of contract means. We are offering an explanation which makes perfect sense, which is that it means ALE. And again, it's not only the merger clause that's at issue here. There's a specific representation that there is no representations outside the agreement that were made. Ms. Day is claiming there was, in fact, a representation that ALE claims were preserved, which is contrary to the agreement. The release says the parties are entering into this agreement to buy their peace. What does that mean? It means they want to end litigation. But the interpretation advanced by Ms. Day would be the opposite. It would mean that they want to continue litigation about what ALE means. I see my time is up. Thank you, Your Honor.
Thank you. Thank you both. People versus Renee Rodriguez.
Thank you, Your Honor. May it please the court, Whitney Elliott of the Legal Aid Society for the appellant Renee Rodriguez. I want to start by emphasizing we are not, in this case, raising a challenge to the voluntariness of Mr. Rodriguez's plea under People versus Catu. And for that reason, the Court of Appeals decisions in Hoti and Guerrero do not control. Hoti and Guerrero addressed whether the court fees at issue here held that the court fees at issue here are not direct consequences of a conviction, that a plea court's failure to mention those in a plea colloquy does not render a guilty plea involuntary. And as a result, a defendant cannot insist on the remedy of plea vacatur on direct appeal. Those cases did not address the claim we're raising here, which is whether the court fees can amount to a breach of a plea agreement.
But the court fees are not part of a sentence.
Well, a court can, we agree with that, but...
So if it's not part of the sentence, how was the plea agreement violated?
Well...
You got the sentence that was promised, right?
He got the sentence that was promised, correct. But plea agreements can contain terms beyond the formal components of a sentence. For example...
And are you saying that the plea agreement, that you could plea away the mandatory court surcharges despite the fact that they're mandatory?
So that would be an unlawful promise, but the way I would frame it, Your Honor, is Mr. Rodriguez here entered a plea to...
Well, if you can't plea it away, then what do you do with them other than impose them?
So if a plea agreement does not contemplate them, like this one, for example, and then...
But why should it contemplate it when it's mandatory and you can't plea it away?
Because...
There are certain sentences that, in fact, do include fees as part of the sentence, but this is not that. This is not something specific to the crime. This is specific to the court system.
So a few things, Your Honor. I just want to get a few responses I just want to get out. So a plea agreements can contain terms that, other than the formal components of a sentence. So the fact that this is not a component of a sentence doesn't mean that it cannot amount to a breach of a plea agreement. So in this particular plea agreement, Mr. Rodriguez was told if you plead guilty, you're going to get a sentence of 4 years incarceration, 2.5 years of post-release supervision. You're going to have to register as a gun offender under GORA, and that's all he was told, and that's what the court purported to impose at sentencing. And then off the record, without any notice to him, a court fee comes in he probably doesn't even learn about until he's incarcerated months later.
Until his commissary is
reduced.
reduced.
They essentially deprive him of his property without any notice, Your Honor. And we're trying to make the point that it's settled New York law that a defendant has the right to insist upon the stated on the record terms of their plea agreement. And it's also a couple other principles. Plea agreements cannot have implied in law terms, and additional terms cannot be added after a plea agreement's terms have been placed on the record. And all we're asking for a specific.
Under your argument, every plea agreement that doesn't incorporate or mention mandatory court surcharges, you cannot impose mandatory court surcharges?
I think they can amount to a breach of a plea agreement, yes. And the breach of plea agreement case law does not say that when a plea agreement contains unlawful terms, it's under no circumstances may courts order specific performances of those agreements. There are cases, we cite Palermo in our reply brief, courts have ordered specific performance of plea agreements with unlawful terms. This court in People v. Wine said, yes, it's very possible that plea agreements will contain unlawful terms, that prosecutors and courts will sometimes make promises that the law does not permit. And if the defendant is...
This doesn't sound like one of those. I mean, this doesn't appear to be one of those. I understand what you're saying, but I'm trying to figure out how this is one of those, a mandatory statutory surcharge.
Well, I just want to be clear about it. So what the plea agreement said, this is what your sentence is going to be.
I understand. It didn't come up. Didn't come up.
It wasn't an express promise. So,
I understand.
So all we're saying is that because there cannot be sort of implied in law terms of a plea agreement, he was effectively told, this is what's going to happen to you. This is what the court is going to do to you. And that's it. So once he's incarcerated, all of a sudden his property is getting taken from his commissary account. That is a breach of his plea agreement. That wasn't contemplated.
Did this have to be preserved by vacating the plea agreement, or did you have to preserve this?
A couple responses to that, Your Honor, because I think there are a couple. There's no preservation argument on the other side, and that's because he had no notice of this at the plea or even at sentencing. It just shows up off the record. It just happened after. He doesn't even learn about it until he's probably incarcerated.
Doesn't counsel know that there's always a mandatory surcharge? I mean, is there ever not a mandatory surcharge because it's mandatory?
Well, I don't think it's incumbent upon counsel to add some other term to the agreement.
But you're saying now that the terms were breached.
That's true.
So it would seem that if you think that there's something else that's a part of it, you should alert the client to it. I mean, it's trying to figure out how you're saying that it's breached, it's mandatory, it's always there.
And in fact, some attorneys ask for it to be waived or, in certain plea circumstances.
Counsel, in your argument, just to follow up, would it have made any difference if the judge immediately said after sentencing and the mandatory court surcharges are whatever they are?
So, yes, I think it would have made a difference to a preservation question, because then at that point, at sentencing, for example.
And what would your argument have been? So it's preserved. So what now? It's a statutory, and now it's been stated. So now what would the argument be?
So, I mean, I think in that case, a defendant in my client's position, for example, could come in and say, well, that wasn't part of the agreement here. And then I think a court could say, well, it's mandatory, so you've got two options. You can either take your plea back or you can just
Can he take his plea back? He's been sentenced.
On the hypothetical, if it's announced at sentencing, I think it would be a principled thing to say for a defendant to say, well, you never told me about that, Judge. That wasn't part of the agreement here. And then the judge could say, well, okay, do you want your plea back? And if he says no, then they can go forward with the sentencing.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Addison Esley for the people.
Well, counsel, I mean, surely it's a better practice to lay everything out as to what's going to happen on the day of sentencing and tell the defendant so that they're aware. But is it a breach of contract if the mandatory surcharge is not disclosed?
It's not a breach of contract, Your Honor, and I absolutely agree it would be better practice to just...
Not contract, I'm sorry.
It absolutely would have been better practice to inform the defendant of this at the plea, but contrary to what my adversary has said, HODI absolutely controls here, and the Court of Appeals has said that a court need not inform a defendant of the mandatory surcharge, because as Your Honor pointed out, it's not part of his sentence. It's not part of the direct consequences of pleading guilty. And so...
What happens when somebody doesn't pay the mandatory surcharge?
Off the top of my head, Your Honor, frankly, I don't know exactly what would happen there, but I would
Does it enhance their sentence somehow?
I would assume there would be some sort of follow-up proceeding, but I do apologize. I don't know the exact penal law sections off the top of my head, but I think what your question's getting at there is the notice to the defendant of these mandatory surcharges, and it's, as the Court of Appeals has said, no extra judicial notice is needed here because the CPL and the penal law both clearly outline how these apply in every single case as a matter of law for every conviction. And so it, as far as what we're really asking here is what did defendant need to be aware of when he pled guilty? And the answer to that question is the judge did not need to inform him of the mandatory surcharge to validly take that plea. And I want to touch on the remedy point a little bit because as my opposing counsel said, this would have been an unlawful promise had this promise actually been made. And because that promise could not be legally enforced, defendant could not have relied on that in making the plea. And indeed, on the record here, there's zero indication that defendant relied on any sort of promise about waiving the mandatory surcharges and fees when he pled guilty. The judge asked him, has anyone promised you anything in addition to the sentence I gave you, to which defendant said no, and it's clear from that that there was no promise to waive the mandatory surcharge and fees. And I'm happy to take any further questions on the remedy point or the other point, Your Honors, but if you have no further questions, the people rest on their brief.
Thank you.
Thank you.
So I guess just a couple quick points in the butt. I don't think the issue here is what did the defendant have to know before he pleaded guilty. Again, we're not challenging the voluntariness of the plea here. I think the question here is what were the stated on the record terms of his plea agreement? And the terms of that agreement are clear, and we're just asking for a specific performance of that agreement. Hody and Guerrero addressed a completely different question. Hody in particular about the voluntariness of a plea. We're not challenging the voluntariness of his plea. All we're asking for is
there a mechanism in the trial court if somebody can't pay their mandatory court surcharges? Is there something that that individual can do? Can they ask the court for something? Can they make some kind of motion, a plea to the court, request?
So I believe there's a motion for a deferral of a surcharge after sentencing based on an inability to pay. But I think we're trying to make the point here. We do recognize that if a surcharge, the court fees here are imposed in a constitutionally acceptable way, they can't be waived on grounds of indigence or hardship or the like. But we're just saying that the fees here weren't imposed in a constitutionally acceptable way in the first instance.
Thank you. Thank you both. NYCTL 2019, A Trust versus 196 East 7th Street.
May it please the court, my name is Douglas Kellner. The appellant in this case was the purchaser at a tax lien foreclosure auction. He had the right to rely on the notice of pendency statute, which says that where someone records an interest after the filing of the notice of pendency, they are bound by all proceedings taken in the action after such filing to the same extent as a party.
That's true.
Go ahead.
So you're asking for a writ of assistance, some way to capture this this person's the property.
To gain possession of the property
Gain
that they
possession of
purchased.
the property. But under a writ of assistance, you have to be able to, what is it? I'm looking at here. You don't have jurisdiction over this person with regard to a writ of assistance under the RPAPL 221.
That's not what the case law cites, Judge. And in this particular case, we gained jurisdiction because we submitted an order to show cause to provide for service of the order to show cause and the paper seeking the writ on the parties. And of course, the respondent appeared and contested it. So they had due process, notice, and an opportunity to be heard. And the cases cited by the motion court, just the opposite occurred, that those parties were not served and did not have due process. And the section of Bergman,
For the RPAPL, it says that in order for you to avail yourself of writ of assistance, that the respondent had to be a party to that action, right? And there's no doubt here that they were not a party to the action. You're relying on the civil procedure law that says that when they fail to record, when they record after no notice of pendency, that they stand in the place and to the extent as if they were a party. But the fact is that they're not a party.
it says to the same extent as a party. That's what the notice.
Right, but
the
it
whole
doesn't-
purpose of the notice of the whole purpose of the notice of pendency statute is to prevent the subsequent shifting of parties after the notice of pendency is filed. And this case falls right on to the text of 6501.
Good afternoon, Your Honors. Kelly Ringston for the non-party respondent cooperative. Your Honors, I'm going to move past RPAPL 221 because you've already made my point for me, which is that there is no question that my client was not a party to the underlying foreclosure action, so RPAPL 221 does not apply.
So why doesn't CPLR 6501, although it doesn't make them a party, it subjects them to the same actions as if they were a party, to
It
the same
does,
consequences?
on the face of the statute, yes, Your Honor. However, the constructive notice provided by a notice of pendency is subordinate to a party's actual knowledge. So what my
The
client,
problem is here, we don't know what.
and my, right, and so my client was the actual tenant in possession of this garden lot. There's no question about that. That's reflected.
About the foreclosure and everything, and years before that.
Since 1999, so decades before. Whether or not the foreclosing party in this case, which is not the appellant, had actual notice is a question that is not addressed in the record. There's nothing in the record to indicate that they did have actual knowledge or they don't.
And that would be an exception under 6501.
It would, and it's of course my client's position that as the actual tenant in possession that had visible possession of the garden lot, the lender should have had actual knowledge. But there's nothing in the record from the lender asserting that they did not have actual knowledge. Finally, Your Honor, I'll just say that in terms of the New York recording statute, that is not available to a post-foreclosure purchaser who had actual and constructive knowledge of an interest. And here, my clients recorded the lease well before the appellant acquired the property of foreclosure. And again, there is actual notice that my client was in possession because they were the tenant in possession. Thank you.
Just a question, how is this not a violation of due process? They're not a party, they didn't have notice, not an opportunity to be heard. So how is this, not a violation of due process?
Because the order to show cause gave them notice, gave them an opportunity to be heard, and they were actually heard. And let me say that the whole structure of the statute here is the requirement that a long-term lease be recorded. So cases that involve residential tenants who have shorter-term leases, none of those cases apply here. Here we had a long-term tenant who was required to record the long-term lease. They have not given any explanation why they did not intervene in the foreclosure proceeding when they learned of the foreclosure proceeding. They did not provide any explanation why they did not redeem after there was a judgment of foreclosure and sale.
There's
and
also
the
nothing in the record as to whether they had actual knowledge of the possession.
They've acknowledged that in their papers, Judge.
No, they did, but your client, or the one that, the party
Remember,
before
my
that
client's the
foreclosed.
purchaser, not the party buying the tax lien. But then also, how does a person who, the entity that obtains the tax lien, know which of the adjacent property owners is a tenant of that property? How does the tax lien holder know what the name of the entity is? So the idea that simply because they had a garden on the property gives constructive notice that a tax lien holder had to go and do an investigation to find out who held that, who was actually occupying the garden in order to foreclose the tax lien, is really contrary to the whole purpose of the statute that requires recording of a 3-year lease and makes a party who files after the notice of pendency bound by the outcome of the judgment.
Thank you both. People versus Samuel Watts.
May it please the court, Barbara Zolot for Appellant Samuel Watts. Your Honors, Mr. Watts is entitled to a de novo map hearing to fully litigate the circumstances surrounding the recovery of his phone.
Counsel, I understand that the defense counsel's cross-examination was limited based on the people's objection that there was no map hearing ordered. However, it seems to me that although it was cut off originally, that defense counsel had ample opportunity to ask questions. And in addition, I don't see anywhere in your papers where you state what it is you would have asked had you had the opportunity.
Right. Well, to begin, even those questions where the objections were sustained is enough to have denied Mr. Watts the full hearing that he was entitled to. The case law is very clear.
But didn't the court give you an opportunity to then follow up once there was some question as to why the motion court did not rule on the map hearing?
Yes, what happened was the hearing proceeded.
Yeah.
Defense counsel wanted to explore the issues around the recovery of the phone.
People objected.
Central issue,
Right.
factual issue there was the prosecution's attempt to establish that Mr. Watts's mother had put the phones in Mr. Watts's pockets.
Well, with regards to how the phones got in the pocket, wasn't that fully explored?
No, Your Honor, because those two questions that defense counsel was asking were directed to the incredibility of the claim that the mother had put the phones in the pocket. And
You had the testimony of the officer, right? The officer was a little unclear in that he didn't remember, and then he testified that the mother put the cell phone in the defendant's pocket, right? Then you have the mother that says, I didn't put the cell phone.
Correct.
Now it's a credibility determination, and the court made a determination.
Well, stepping back, it's not just those questions that he wasn't allowed to pursue, which would have gone to furthering perhaps this credibility question, but also defense counsel, had he had a full hearing, may have, and we don't have a burden to show that he would have, but he may have wanted to present additional evidence. There were other police officers present besides Garcia, who was the only witness the people chose to present on this question of what happened in the apartment. But there were other police officers present, and Mr. Watts himself, who defense counsel at a
Were you foreclosed? Did the hearing judge foreclose you from calling other witnesses or calling your client?
Well, the hearing court denied the defense counsel's application to grant a map hearing. The hearing court, I have the pages of that. What happened was, it was
Nobody realized that he didn't, even the counsel didn't realize that he had requested the map hearing because he said, I don't know.
He did ultimately realize that the court ultimately acknowledged that defense counsel did in fact request a map hearing, said that the allegations
That was
aren't...
at the hearing court, not at the court that decided whether he was going to have the hearing.
The hearing court, not the motion court, the hearing court, when this was all being discussed and everyone was trying to kind of suss out what had happened originally, the hearing court ultimately denied defense counsel's application to grant the map hearing at that point, at the hearing, while acknowledging that defense counsel had in fact requested one, stating Justice Dwyer denied it, I don't know why.
it's true this is not a model of clarity, but isn't it so that the hearing court ultimately said, although it wasn't ordered by the motion court, we're going to deal with it, and suppression denied? They might have said map hearing denied, but it's suppression denied.
Yes, yes, but what the court was doing was deciding suppression after it had denied defense counsel's very request for the full map hearing that needed to be held to support the court's ultimate ruling. So the court was ruling on suppression after having specifically denied defense counsel's request for the hearing. I mean, there's a
Wasn't
certain
there a
irony
hearing?
there.
But there was a hearing.
There was a hearing on Payton, on Huntley, and then there was this ersatz thing where defense counsel was trying to probe the issues around the map, was cut off in some of his efforts, was able to ask some questions, but ultimately when defense counsel said, well, Your Honor, what the court originally ruled, I know it's very kind of messy, but the court originally ruled, in its original ruling, what it said was, there was no map hearing ordered. That's after the testimony came out. There was no map hearing ordered, so it wasn't going to rule on that. Defense counsel kept revisiting it and kept pressing.
Counsel, you're right. I see it here.
Yes.
I see here in where it says your application for a map hearing at this time is denied.
Yes.
Then the court went on to rule on a map hearing.
And that's our very complaint. The court compounded the error by ruling after it denies defense counsel's application to conduct the full hearing that defense counsel
I guess so. That's the
wanted.
question. I guess that's why I'm really challenging you is
Yeah.
what is it that you were unable to do?
Yes, and where our position is, we don't have to say exactly what it would have been, but there was certainly the potential to do more. There was certainly more cross-examination, more witnesses. We could have tried to corroborate Ms. Sosa's testimony that that she believed the phones were taken from the Bureau. The court really hinged its ruling on she only believed they were taken from the Bureau, and we have Garcia's testimony that she put
So
them
the
in the
court just relied on the officer's testimony and her testimony, and you're saying you could have put in other testimony.
Correct.
Or expanded that testimony.
Yes, yes. Thank you.
Good afternoon. May it please the court. Rachel Bond for the people.
So this is quite messy,
Yes.
right? And why isn't your adversary correct?
So the court here had plenty of evidence before it to make a
It's not
reasoned
about
decision.
plenty. It's about whether the defendant's opportunity to present its defense was cut short.
Right. So from the record that we have here, and I would say based on the arguments that defense counsel made below, based on the testimony of the defendant's mother he chose to present, he really went into this presenting his map case. That was the evidence that he wanted to present on
Right.
that.
Is that
So you objected.
right?
So we did not object to him entering any of the evidence that his mother gave. And she admittedly could not testify as to any of the issues related to the Payton, Dunaway, or Huntley issues. She was only testifying about the suppression of the phones, or the recovery of the phones. And additionally, the people did object after defense counsel had already asked several questions of Officer Garcia regarding the recovery of the phones. And I believe we actually only objected after he had already asked the question that he asked, so it was cumulative. So he had asked him, isn't it a fact that you picked up the phones and took them with you? And then they go into...
The way you're presenting it, I think is the way it happened factually. But there is also no doubt that the judge denied the request for a map hearing.
Yes, and then as Your Honor stated earlier, the judge then did say, to the extent that it has come up at this point, I'm going to go ahead and rule on the map.
Right, with the limited information that she had after she shut down the defendant.
Sort of a due process argument, that they didn't have the fair opportunity to do what they should have been able to do. Or could have done, because nobody addressed the map hearing, and she addressed it only after it was already, it was denied, they gave some testimony, and then she said, okay, oh, all right, I'll rule on the map hearing, but they're saying they would have done so much more. They didn't really, weren't able to hold a full map hearing as they would have.
So again, to the extent that defense counsel was limited in cross-examining Detective Garcia or Officer Garcia, I think that...
It's more than that. It's more than, it's not only that they were limited in cross-examining the officer, they were limited in calling other witnesses.
So they were not limited in calling other witnesses. They rested after presenting the testimony of.
But
they
the
were
other
denied at
witnesses
that
would have
point.
went to the map issue, right? And the court, up until the final point, wasn't allowing that.
Well, but the court at that point, so again, defendant presented his mother's testimony, and that really only went to the map issue, and then defendant rested. There was no objection to anything
Saying
of the
that
mother's
the
testimony.
defendant never preserved his right, never said, but Judge, we didn't really get the opportunity to do a full map hearing here. We'd like to be able to call more witnesses and actually do the map hearing before you rule on a map hearing.
To a certain extent, yes. I mean, he had the opportunity to try to call more witnesses and did not do so. And additionally, his application.
How could he have done that if the court had told him there wasn't going to be a map hearing?
Well, I don't believe that discussion had happened at that point. There was an objection made, and he said this goes to the map portion. The prosecutor said there is no map hearing, and then defense counsel said, I believe this goes to the Payton portion of this. And then the court, rather than sustaining or overruling the objection, just said, ask your question, and allowed him to ask more questions. So that at that point, and again, that was in the cross-examination of the officer, defendant was not limited in calling further witnesses if he had wanted to call further witnesses.
So after the court stated that your application for a map hearing at this time is denied, I wish I had all the minutes, but I don't. Was testimony taken after that?
No, but that was after defense counsel had already rested their case. That was after arguments had
So
been
you're
made.
saying that the court officially denied the request for a map hearing after defendant rested?
Yes.
But how would they have known to have other witnesses lined up if their request for the map hearing had been denied?
Well, so I think, again, really by the way the arguments that were made, especially reading the arguments that defense counsel made after the close of the evidence of the suppression hearing, he was making a map argument. And during the sort of discussion where it did get a little messy and a little bit confusing.
Well, then the better practice would have been to just grant the map hearing. I mean, it happens all the time. As the evidence is pointing in this way, I think I'm going to go ahead and grant a map hearing. That didn't happen.
Certainly. So if the judge had granted a map hearing at that point, things may be a little bit easier to decipher on appeal or a little bit less messy. But I do think that the judge had enough evidence before her to decide that the cell phones didn't need to be suppressed.
I think, you saying that she had enough, for what? She had enough to rule the way she ruled, maybe, but she certainly didn't have what the defendant wanted her to have, right?
But I think
Which is more.
But I think it's unclear, as was stated during my adversary's argument, what else would have
They
been
didn't state that. That's
offered.
true.
Yes, and I think at a certain point, it's not their burden to say what else should be presented, but at a certain point, the question is going to be asked of them. And so I don't think that it's improper to say that they should be making a proffer of what that evidence is going to be. And I don't think it's clear what other evidence there could be that would have changed the outcome of this hearing. And then ultimately, even if these phones should have been suppressed, the evidence that was entered at trial from these phones was certainly not the linchpin of the people's case. And so
It was quite important, though, right?
It
connected the defendant to the co-defendant.
I would push back on that, Your Honor, because at trial, defendant did not contest that he and the co-defendant Vega, so it didn't really connect him with Velazquez. It only connected him with Vega, and he did not contest at trial that they knew each other. And additionally, the only other evidence that was admitted from that was photos of the defendant to tie him to the phone, but he admitted that was his phone number, so that wasn't
the internet searches, right? And the searches.
Yes, which was just consciousness of guilt evidence, and there was already other consciousness of guilt evidence as well. So I would say it's certainly harmless error, if any error at all, but I would also argue that it was not error for the court to deny the map hearing here.
Thank you.
Thank you.
Okay, starting with this last point about harmless error, you know, we are operating with constitutional harmless error, this which has been called, I believe the language is the most daunting test yet formulated, putting aside whether the evidence was overwhelming or not, which is the first question, and point 2 of our brief addresses that, just dropping down to what the people would have to prove for harmlessness, which is proving
It's beyond a reasonable doubt.
yes, Yes, no reasonable doubt. And at least in 3 ways, we could say that this evidence might have the possibility.
So what's the remedy?
So the remedy should be a remittal for a de novo map hearing. That is what we wanted, and that is what we didn't get. As for the other points about defense counsel somehow, at some point, chiming in with, well, this is what I want to do, Your Honor. During the testimony, after the court had sustained the prosecutor's objections to his cross on the ground that no map had been ordered, I believe would be the ultimate in futility for counsel to then say, but Your Honor, I actually want to call witnesses that would be relevant to the map portion after the court just sustained the objections. And then after that, at the point where it was page 185, at 184 through 186, defense counsel at 185 asked the court to grant a map at this point. That's after it had initially ruled, and then there was more discussion of it. The court then denies that application. Defense counsel's
So at
job
that point, had
was
defense
done.
counsel, I'm sorry, had defense counsel rested?
Yes, defense counsel's job was done at that point because he had asked for the map hearing. He was denied. Preservation was complete under CPL 470.05. Nothing more needed to be done to protest the court's mistakes in this regard. If there are no further questions.
Thank you. Thank you both.
Thank you.